Welcome, everybody, and happy Valentine's Day. Thank you for joining us on this special day. The Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School welcomes you to Sacred Rites, Psychedelics, Law, and Spirituality. This is the 2025 conference for Pulse, a new project founded at the Petrie-Flom Center last year. Pulse is an acronym for Psychedelic Use, Law, and Spiritual Experience. The first two parts of that name, psychedelic use and law, have a long and rocky history. It's still unfolding before us today. But the third part, spiritual experience, predates any of our laws. When you think about psychedelics, you might imagine psychoactive chemicals synthesized in a lab. You might imagine clinical trials for a new treatment for depression or post-traumatic stress disorder. You might think of the 1960s or the Beatles and rock and roll and political protest. You might also think about plants, fungi, animals around the world that are part of complex ecosystems that are venerated by people around the world and are part of their spiritual and cultural traditions. For many people, psychedelics are a source of healing, of community, of connection. They may represent a portal to a spiritual realm, or they may represent spirits themselves. And Pulse is a project where these worlds and contexts come together. And it's at these intersections of medicine and spirituality, of individualism and community, that we find very challenging ethical and legal questions, and that's what Pulse is investigating. We have a wonderful group, our first cohort of Pulse-affiliated researchers, most of which are here today, and you'll hear from some of them on our panels. And they have incredible expertise in a variety of different religious traditions. There are historians, healthcare providers, therapists, psychologists, psychedelic chaplains, and of course, many of them are also lawyers. Can't forget the lawyers. Pulse is part of the study of psychedelics in society and culture of Harvard University and the Mahindra Humanities Center. Its research and programming are supported by the Gracias Family Foundation. And this event is also supported by Poplar, the Project on Psychedelics Law and Regulation at the Petrie-Flom Center, which is our first project focused on psychedelic policy. And I want to thank the SciSay Foundation, Tim Ferriss and Matt Mullenweg for their support of Poplar. Also want to thank the Petrie-Flom Center's faculty director, Glenn Cohen, the executive director, Susanna Baruch, and Laura Chong, Lisa Gorelick, and Aaron Lynch. I encourage you to visit the website for Harvard's study of psychedelics in society and culture, where you can learn about upcoming and recent events. There are book talks, film screenings, lectures, conferences like this one, research, and you, while you're there at the website, you can sign up for the newsletter that will keep you updated on all of this exciting work that's happening here across the university. Thank you again for joining us. Let's get started with our programming. We are very fortunate to be joined virtually by Brian Muraresku, who will provide our keynote address. Brian is the author of the New York Times best-selling book, The Immortality Key, The Secret History of the Religion with No Name. This is from the book publisher. Muraresku takes the reader on his 12-year global hunt for proof for the original Eucharist, the sacred wine said to guarantee life after death. He tours the ruins of Greece with its government archaeologists. He gains access to the hidden collections of the Louvre. He unravels the ancient Greek of the New Testament with a Catholic priest. He spelunks into the catacombs under the streets of Rome to decipher the lost symbols of Christianity's oldest monuments. He breaches the secret archives of the Vatican to unearth manuscripts never before translated into English. and which, with leads from the archaeological chemists at Penn and MIT, he unveils the first scientific data for the ritual use of psychedelic drugs in classical antiquity. So it's quite an exciting part Indiana Jones and Dan Brown novel. So definitely pick up the Immortality key. And welcome, Brian. We're so happy to have you with us to kick off our Pulse 2025 conference. Thank you so much.
Thanks for your patience. So as Mason mentioned, back in 2020, I published a book about my quest for the ritual use of hallucinogens across the ancient Mediterranean, the cradle of Western civilization. And my research built off generations of scholarship probing whether the founders of ancient Greek logic and rationality would have cultivated states of consciousness defined by psychedelic illogic and irrationality, and what influence, if any, their many mystery cults may have had on the early days of Christianity. And even a few years ago, such practices in the so-called West were deemed rather more controversial than those among traditional societies the world over, as documented by the likes of Harvard ethnobotanist Richard Evans Schultes, whose Plants of the Gods, Origins of Hallucinogenic Use, originally published in 1979, remains a landmark study. So we'll never know when and where humans first discovered the mind-altering power of psychedelics, but it seems fair to state three things about our relationship with visionary drugs. It is incalculably old, it is globally pervasive, and it is often the subject of fierce debate. Our ancestors likely began their long journey with naturally occurring psychotropic substances tens or even hundreds of thousands of years ago. Indeed, the late psychopharmacologist Ronald K. Siegel called the human pursuit and use of drugs the fourth drive, a motivational force no less instinctual than our desire for food, drink, and sex. But we're not alone. From goats foraging on coffee cherries, to bees slurping the mad nectar of rhododendrons, from elephants snacking on fermented fruits to baboons craving tobacco. The quest to alter consciousness transcends our species. And in my 12-year hunt for the hard evidence of psychedelic use in the classical world, I ventured beyond the dusty texts of my classical training into the sciences of archaeobotany and archaeochemistry. And after many years of sleuthing, data from a pair of 2,000-year-old vessels emerged from Spain and Italy, suggesting that the ancient Mediterranean, just like its sister cultures around the globe, was indeed home to advanced pharmacological knowledge whose true scope is still very much unknown. And since presenting those findings in 2020, several peer-reviewed papers have been published which confirm the general hypothesis about the region, including the 2023 study by my friend Elisa Guerradose in the Escariche Cave on the island of Minorca off the eastern coast of Spain. She uncovered the alkaloids atropine and scopolamine in hair samples tucked away in a sealed grotto. Dating to some 3,000 years ago, the chemistry suggests the ritual ingestion of visionary plants from the notorious nightshade family. See the New York Times article, Tripping in the Bronze Age. In addition, more evidence for, quote, ancient ritual practices was confirmed in another recent study of a drinking mug in the shape of Bes, the Egyptian god of fertility and childbirth, dating back to the Ptolemaic period of the 2nd century BCE. And published in the prestigious journal Nature by Davide Tanasi and Branko van Open, amongst others. This Bes mug tested positive for the alkaloids found in Syrian rue and blue lotus, or the blue water lily, which would have altered the consciousness of women, it was thought, engaged in yet more ritual. Ritual conducted in those mysterious Bes chambers built at the site of Saqqara near the Egyptian capital Memphis, south of Cairo. Okay, what does any of this have to do with us today? Well, I tried to capture the implications in the conclusion to my book, the likely availability of one or more psychedelic drugs within federally regulated settings by the year 2030. A distant, and I would say inferior echo of the rituals I had been examining. At the time, I considered it an incomplete thought experiment, a bit of a thumbnail sketch, unaware of the contentious debate in front of me. So in the wake of our culture's failed experiment with psychedelic drugs in the 1960s, and the failed war on drugs that followed it, disproportionately impacting people of color, what was the direction ahead? Let me be very clear. Today, just as it was in 2020, I have no idea. And as more questions came my way and I was able to produce less answers, I set my sights on the campus that had not once, but twice rejected me. Once for undergrad and again for law school, which especially hurts because my wife went to Harvard Law School. The same campus that was home to one of the nation's leading classicists, Greg Naj, who didn't laugh me out of his office when I first approached him with an absurd research project many years ago, and the same campus that played no small part in generating the national debate around psychedelics in the first place. Not only the Harvard psilocybin project that would influence 1960s counterculture, but the ethnobotany of Schultes, and even the 19th century musings of another Harvard luminary, William James. The psychedelic debate had a long history in Cambridge. Bit by bit, together with Michael Pollan, an idea emerged with my fellow counselors at the law school in conversations with Glenn, Mason, and Susanna, the inquiring spirits at the Divinity School, and colleagues across the Faculty of Arts and Sciences for an academic forum to discuss these incredibly complex issues. This is where the conversation belongs, in my opinion, with all disciplines lending their expertise. Thanks to that philanthropic generosity of the Gracias Family Foundation, today's gathering is another wonderful and perhaps unique example of that interdisciplinary collegiality and goodwill. As in meetings past, there will be no resolution today, and I think you're all engaged in the delicate work of framing, not answers, what in law school we called issue spotting, an exercise that will necessarily last many, many years, likely decades, and if intended to strike the right balance between personal freedoms and public health, with a nod to ancestral wisdom, will literally take generations. We should be in no rush to repeat the naivete of the 1960s. Even with the best of intentions for mental health, psycho-spiritual well-being, or even self-discovery, this is going to take time. So let me be very clear. Based on my investigation of historical precedent, I don't think we as a culture are in any way prepared for the psychedelic experience at scale. At least the kind of experience I've been able to detect in the ancient record, where highly ritualized and systematized initiation experiences, curated by professionals and enforced by strict codes of conduct, were the norm. They were the proto-scientific fora for investigating the self and the very nature of reality, amidst a culturally sanctioned worldview that embraced and promoted the concept of the soul, which is what psychedelic means, that which unleashes the soul, a part of us that is thought to exist beyond time and space. That's not the world we live in today. All that said, it doesn't mean we can't issue spot how the slow, measured, methodical use of psychedelics might re-enter our society across at least 4 domains in the years ahead. So to start with the obvious, it's already happening in the medical domain with state and federally appropriated funds. Last December, the Department of Veterans Affairs announced the funding of its first study of MDMA for PTSD and alcohol use disorder among veterans, the first such study since the 1960s. As with any drug, the study will look into safety and efficacy by examining dosage and side effects, adverse events, all the pharmacokinetics and pharmacodynamics that you'd expect. And they'll do proper intake, screening out those with personal or family history of psychotic disorders, cardiovascular issues, and those on certain medications. But almost immediately, the conundrum appears. Unlike other drugs, the perceived benefits of MDMA and other psychedelics are thought to occur in a months-long process, maybe years-long. The combination of the drug itself plus psychotherapy during the preparation, administration, and integration of that experience. Across the wide spectrum of psychedelics, it's an experience that can be deeply unsettling, disruptive, and even destabilizing, and it may require expertise beyond the allopathic medical model. To wit, this isn't just the stuff of irrelevant Cambridge discourse. On August 9th of last year, Congressman Jack Bergman, Republican from Michigan, and Luis Correa, Democrat from California, released a bipartisan open letter on behalf of the PATH Caucus, Psychedelics Advancing Therapies Caucus, calling for public comment on best practices for psilocybin and MDMA policy and regulation. Within the medical domain, they ask, what would truly make these interventions responsible, accountable, safe, and ethical? Because of the complexity of the psychedelic experience, however, language from that letter, language that is now part of the official congressional record, includes phrases such as the biopsychosocial spiritual behavioral health ecosystem. And there's a nod to the significant anthropological role of psychedelics across history, including in spiritual, ceremonial, or ritual healing practices. This concern from the congressman dovetails with recent articles in medical journals about the spiritual, existential, religious, and theological, so-called CERT resources that may merit inclusion in existing clinical trials and emerging medical models. So if this is medicine, quote unquote, it already resembles nothing in our current healthcare system. Are we regulating a substance or an experience? That was the question posed by our friends at the Center for the Study of World Religions at Harvard Divinity in a piece last year entitled An Interdisciplinary Look at Psychedelics and Ethics. Now, it would seem the VA, the largest closed-loop healthcare system in the country, might be an ideal venue to begin asking those questions and undertaking a massive data collection exercise that charts what works and what doesn't, to research and develop best practices whilst responsibly, accountably, safely, and ethically treating a discrete population of veterans desperately in need of relief. In the absence of the warped incentives embedded in the for-profit pharma model of drug development, racing to scale to maximize a bottom line, here's a nice alternative: slow, measured, methodical. Now, as for the second bucket, you're all gathered here today because of a co-equal constitutional concern presented by our First Amendment and legislation such as the Religious Freedom Restoration Act, or RFRA. Not to mention the simple fact that 99.9% of psychedelic use since the origin of our species has occurred outside the clinical setting or traditional healthcare system. In May 2024, a great piece in the New York Times did the issue spotting. It's entitled Drugs, Sacraments, or Medicine? Psychedelic Churches Blur the Line. Because of two Supreme Court decisions, the Smith case in 1990 that allowed the use of peyote by the Native American Church, and the Gonzalez case of 2006, allowing the use of ayahuasca by the União do Vegetal, a church that began in Brazil, there already exists First Amendment protections for the, quote, sincere religious use of psychedelics. And by some accounts, there are now an additional dozens, scores, it could be hundreds of other psychedelic churches operating illegally, but claiming the same constitutional protections as the NAC and UDV. In 2023, the Cato Institute forecasts that the rise of such churches because of a challenging legal landscape, decreasing social stigma, and a growing mental health crisis. Quote, in the short term, increased demand for psychedelics and limited legal supply will serve to further the growth of the religious use sector, a possibility which former DEA agent Anthony Coulson is quoted in the piece as calling a disaster down the road. The convergence of twin crises, public health and constitutional. Now, while a RFRA exemption process does exist under a 3-page DEA guidance document, the DEA, to my knowledge, has never granted such an exemption for any faith-based organization, something that prompted an unprecedented report from the Government Accountability Office just last May. It's entitled, DEA Should Improve Its Religious Exemptions Petition Process for Psilocybin and Other Controlled Substances. It's a nice example of government yelling at government. So completely separate from the medical question, how is the federal government going to manage the mushrooming, no pun intended, of all these de novo churches in the years ahead, let alone the potential exploration of psychedelic ceremony by some of the larger existing communities of Jewish, Christian, Islamic, Hindu, Buddhist faithful across the United States, perhaps in a palliative care or hospice setting? Should that be the exclusive purview of the DEA? Questions you might explore today include, what is the appropriate state and federal involvement in such religious use? Given the Robert Court's disposition towards religious freedom, is the Supreme Court likely to grant cert on a third case, like Smith and Gonzalez in the years ahead, a case that will at last provide some clarity? What about the Establishment Clause theory and doctrine as it pertains to psychedelics? Looking to the Divinity School, what are the religious uses documented across history, and how might they inform current law and practice? What are the ethical and legal challenges of a so-called psychedelic church? What are the duties of today's religious institutions and practitioners? What is the appropriate role of religion or even spirituality in psychedelic research and clinical practice? What is the evolving role of psychedelic chaplains in hospice and palliative care? Perhaps most importantly, is any of this a good idea? I mentioned the warped incentives of for-profit pharma maximizing scale. What about the warped incentives of recruiting and retaining members of a congregation, using substances that can put people in a very vulnerable position, where they can be subconsciously primed in all manner of unpredictable ways? Look no further than the sordid history of MK Ultra in the 1950s and 60s, the weaponization of LSD as mind control, a technique employed by Charles Manson to indoctrinate his followers. So on the smaller scale, when does a psychedelic church become a cult? And on the larger scale, how does a global religious institution, especially one with a history of abuse, even enter the debate? Can it provide ethical pastoral care, say at the end of life, with external accountability and oversight? And then there's a third scenario, the one that's largely the focus of my research into antiquity, the ritual use of psychedelics that is neither medicinal nor religious, but a category all its own. Those rites of passage I mentioned before, highly ritualized and systematized initiation experiences, curated by professionals and enforced by strict codes of conduct among relatively small groups of people, experiences that were infrequent, perhaps only once in a lifetime. Today in the West, we don't have those. Within many traditional societies, however, such practices are alive and well and may stretch back centuries or millennia. The practitioners of the Bwiti religion in Gabon, for example, employ the potent hallucinogen iboga to allow initiates to be born into the unseen and come to know death and the land beyond, where there's often a meeting with deceased ancestors. And this is very common, by the way. Ayahuasca in the Amazon basin actually means vine of the soul or vine of the dead. In Michael Harner's The Way of the Shaman, first published in 1980, the author reports an encounter with ayahuasca that ushers him to the brink of death, where visions reveal, quote, secrets reserved for the dying and the dead. And you find this again and again across the literature. After 12 years of research, I was persuaded something like that was happening at Eleusis, the spiritual capital of the Mediterranean for the ancient Greeks. It ran for 2,000 years on the promise of guaranteeing immortality to its initiates. Now, could something along those lines have fueled the rituals in the Menorcan cave or those mysterious best chambers south of Cairo? Some secrets die with the dead. Others, within existing indigenous culture today, I believe, are best left uncorrupted by Western minds. And this is what really interests me about the psychedelic experience. Neither medicinal nor religious, something perhaps philosophical or better existential, something truly universal to all humanity, something that's agenda-free with no doctrine or dogma or ideology, the simple act of dying before dying. I can think of no medical or religious institution, no psychedelic church, no Grateful Dead concert that will be able to deliver the kind of experience that literally takes centuries or millennia of iteration to perfect, and that has undeniably gone missing from Western civilization. Keeping in mind there are countless other ways without drugs to architect that kind of experience today, ideally with the aid of elders and wisdom keepers, starvation, sleep deprivation, dark retreat. So when I say this is a generations-long project, that's kind of what I mean. Now, finally, any self-respecting libertarian constitutionalist or strict individualist would be remiss not to at least mention another alternative, especially in an age of ever-increasing decentralization. Among mature adults, and I would add sometime after the age of 35 or 40, what right does any government have to stand in the way of self-exploration? What is the jurisdictional basis for prohibiting the personal use of naturally occurring, non-habit-forming alkaloids in the organic flora and fauna that surround us, or enigmatic tryptamines like DMT that our own bodies endogenously produce? About DMT, my friend Joe Rogan has said, the most profound, shocking thing in existence is only 3 hits away. The kind of experience which, by the way, may be implicated in the advent of civilization or democracy, perhaps human consciousness itself. I'll end by quoting Ronald Reagan, whose Just Say No campaign clearly had a big impact on my maintaining my psychedelic virginity. But he also ironically said that government exists to protect us from each other. Where government has gone beyond its limits is in deciding to protect us from ourselves. I can think of any number of risky ventures that receive minimal government regulation. I can pick up my phone and gamble away my entire life savings, purchase a lethal dose of gin straight to my front door, or go free solo El Capitan in Yosemite, plunging to my death. And no state or federal authority will stand in my way. Now, that's a legal debate for a future gathering, I imagine, and it's to be noted that the free solo of DMT in middle age is definitely not for the faint of heart, and I have no idea what I'm talking about. But at this stage in my life, having developed a healthy mistrust of most human beings, this seems to be the direction I'm heading, a once-in-a-lifetime duet with the self-transforming machine elves. Back to this afternoon's agenda. In my book, I mused whether the re-entry of psychedelics in the 21st century could save a religion in decline and a civilization in crisis. Having reflected on the critiques and witnessed the evolution of the psychedelic debate, my own views have evolved, which is a good thing. As I've said, I don't think we as a culture are in any way prepared for the psychedelic experience at scale. Nonetheless, you're here today to discuss the multidimensionality of that phenomenon, part medical, part religious, something else altogether perhaps. Can our current healthcare system or religious landscape really create the sacred containers that reflect the vast reverence our ancestors held for this experience, most profound and shocking? Reverence that took centuries and millennia to harvest. When it comes to the exploration of consciousness or the soul, we are babies. There are lots of ways to explore the soul without drugs, and yet experimentation is happening. So where is that constitutional balance between personal freedoms and public health? You won't find it today or anytime soon, but I'm heartened to know that keen minds like yours are engaged in the generational conversation and the issue spotting, and you should continue to welcome disparate voices from across the country and around the world. Our society deserves your slow, measured, methodical analysis, and I hope future generations will look back on this moment and find our humility in the face of the sublime. Thank you.
Thank you, Brian. You've given us so many great threads to pull on. We'll hear about all these things, the Smith case, the UDV, RIFRA. We'll talk about all these issues on our panels. And thank you for your wonderful book and all the work that you do. Really appreciate you. Thank you. Let's have another round of thank you for Brian. We're going to roll right into our first panel, and then we'll take a break afterwards. Our first panel is about law and practitioners, psychedelic practitioners and the law. And we'll hear from people who actually represent psychedelic churches, people who are experts in various religious traditions. And I'll turn things over now to Victoria Littman. Thank you.
I'll invite our wonderful panelists up now as I'm introducing. Hello, everyone. My name is Victoria Littman. I'm a visiting professor of law at Roger Williams University School of Law. I teach torts, cannabis law, and psychedelics law. I'm also very fortunate to be a fellow in psychedelic law and spirituality at the Petrie-Flom Center for Health Law Policy, Bioethics, and Biotechnology. As part of my work this year, I've been focusing a lot on Pulse, which Mason introduced. I'll say, given the topic here, I myself am a believer in the power of religious and spiritual experience to translate into strong communities, inspired people, positive social change. I've studied religion at an undergrad and graduate level and published on the topics of religion, psychedelics, and the law. I'm very delighted to introduce and moderate our panel. Each of our speakers will give a 15-ish minute presentation. I'll offer them a moderator question, and then we will open for Q&A, so be thinking of your wonderful questions. I'll just say, while the primary approach to changing the legal status of psychedelics in the United States has focused on medical or therapeutic applications. As we just heard, psychedelics consistently and historically facilitate mystical or spiritual experiences, at least in certain contexts. And this reality raises a lot of crucial questions. How should we regulate these experiences? What does it look like to integrate psychedelics into established religion? How should we define religious sincerity as related to psychedelic practices? Who should be in the position of deciding whether or not something is sincere? How can the psychedelic field, defined broadly, face these and other challenges head on? So one takeaway that I hope you'll have from today's panel, there will be many takeaways, is an increased appreciation for how our country's legal and regulatory system often struggle to define, protect, and further psychedelic religious freedom, and how the law necessarily, and sometimes perhaps detrimentally, shapes religious ideas, practices, and the development of new religions. So without further ado, I will begin with our first panelist, and I'll come sit and join you. Rick, take it away.
Thank you very much. Share a tiny bit about me. But before I walked in, I read a bunch of the quotes that are on the wall out there, which are very inspirational, but they're about just and unjust laws. So I was a draft resistor for Vietnam, did not register for the draft, thought I would go to jail, and that would be my protest. So at an early age, I learned that there's a difference between what's moral and what's legal. And I've basically adjusted my life according to what I think is moral, regardless of what happens to be the case of the law. This also requires sort of standing up and trying to change the law when you think that it needs to be changed. So when I was 18, I identified myself as a counterculture drug-using criminal. And the arc of my life, now I'm 71, has been to try to go from counterculture to culture, from criminal to legal, and I've found that I have retained my interest in using psychedelics and other drugs and medicines throughout the lifespan. There was kind of a famous quote that Ram Dass had early on after the crackdown against psychedelics, and what he said is that, a lot of people were moving into meditation away from psychedelics, and so what he said is, when you get the message, hang up the phone. But that's a fundamental misunderstanding, and I think he realized that later on in his life, is that there's lots of different messages according to which stage of life that you're in. Different messages when you're trying to figure out what you want to do with your life, different messages when you want to figure out in middle age and what's your purpose, and then near the end of your life when you're thinking about death and your legacy and things like that. So there's, for me at least, has been a lot of this transformation, and a big part of this transformation for me was this move from training to become an underground psychedelic therapist, and hopefully then an above-ground psychedelic therapist, and then realizing that in the 80s that I was unable to get into a clinical psych PhD program to study psychotherapy outcome with psychedelics because the politics was in the way. And one of the tools that I use to help me when I'm trapped in a box is marijuana. And so I try to think things in a fresh kind of out-of-the-box kind of thinking, and I realized that since this pattern, I want too much too soon, and what I want is to do the science, but the science is blocked by the politics, so therefore I needed to study the politics, and that led me to the Kennedy School. And that's where I started changing my sense of who I was from being counterculture to culture. And hopefully, I still got a ways to go from being a criminal to being legal. But hopefully we're all moving in that direction. So I want to share just one really interesting story initially about the role of spirituality in what we think of as really the origins of the research into whether psychedelics can produce mystical experiences. And that was the Good Friday experiment that took place at Mars Chapel in 1962. And that was Timothy Leary's student, Walter Pankey, who was both a minister and a doctor, and he was working on his PhD. And his PhD became this study about trying to look at psilocybin and whether it could produce genuine mystical experiences. And they were looking around where could they conduct this study. And so they Walter Pankey contacted Reverend Howard Thurman, who was at Boston University at the Mars Chapel. And Howard Thurman agreed that he would permit this experiment to be done in the basement chapel during Good Friday service. The reason that he was interested, that Howard Thurman was interested, is that he had previously studied with Gandhi. And he had really learned about the role of nonviolent resistance in political change as inspired by people's spiritual and religious understandings. And then later, in the 50s, Martin Luther King went to Boston University and got his PhD from Boston University, and his mentor was Howard Thurman. So Howard Thurman really is this through line from Gandhi and nonviolent resistance to Martin Luther King and introducing that into the U.S. civil rights movement. And this was this idea of the spiritual mystical unit of experience and the political implications of that. So we see that sort of this early research was both politics and spirituality within kind of a scientific frame. And I think that we need to kind of keep that alive in our sense today. Now, one of the things that I think has been overlooked a little bit is that from the research that was done in the 60s with LSD and psilocybin, it was done with cancer patients who were scared of dying, it was done with alcoholics, it was done with heroin addicts and others. And what they showed was that there was a correlation between the depth of the mystical experience as measured by the mystical experience questionnaire that was created by Walter Pahnke for the Good Friday experiment. So there's a depth of the mystical experience is related directly to therapeutic outcomes. And that has been replicated over the last 20, 25 years of the resurgence, the psychedelic renaissance. So with all the classic psychedelics, the stuff that's come out of NYU and Hopkins and the rest, they have shown that when you talk about the reduction of tobacco addiction, the reduction of alcoholism, the reduction of fear of death, depression, all these different studies with the classic psychedelics have identified this same pattern, that the depth of the mystical experience is correlated with therapeutic outcome. And so how do scientists and all think about this? Now, with our use with MDMA for post-traumatic stress disorder, which we've been studying now for about 24 years also, we decided that we would explore to see whether there is a similar correlation. So we use the same mystical experience questionnaire, and people tend to score pretty high, but not as high as they would do with the classic psychedelics, but there's a substantial number of people that score above this threshold for a full mystical experience. But what we've discovered is that there is no correlation when it comes to MDMA-assisted therapy for PTSD with the depth of the mystical experience. We do use a measure that's post-traumatic growth. And this is about how you confront, sometimes in traumas, you think you might die, you think you might be killed, something like that. And that causes you to reevaluate, what do you want to do with your life? What are your priorities? These are the kind of post-traumatic growth aspects of it. So we haven't really looked yet, but there may be a correlation between depth of mystical experience and post-traumatic growth, but not in recovering from PTSD. And so that's something that I try to make a point of, to say that in our therapeutic approach with MDMA-assisted therapy, we're not trying to steer people to a mystical experience. We're trying to support whatever's emerging. And it may be spiritual, it may be mystical, it may be childhood memories, it may be birth trauma, it may be transpersonal experiences, it may be specific things, but there's no effort in our mind to try to move them towards this kind of unit of mystical experience, this beyond ego state. And so there is sort of a fundamental differentiation between the classic psychedelics and how they are used in therapy and drugs such as MDMA. Now, some of the concepts that we've had about supporting whatever is emerging, we've kind of encapsulated in this phrase, inner healing intelligence. And the concept of this idea of this inner healing intelligence is that we all know that our body regenerates itself below the level of our conscious awareness. There is this inner healing intelligence built into our physical form. And the theory is that there's something similar in our psyche, that when you have a psychedelic and you, one way to think about it is that there's like a membrane, a permeable membrane between the conscious and the unconscious, and that psychedelics make this membrane more permeable, similar to what happens in dreams, that this is, the idea of the inner healing intelligence is that it's something that we don't know what's happening, we don't actually know. And sometimes the patients don't even know what these physical pains or what these fears or emotions, things lead to, but we believe that there's something healing in opening up to whatever it is. And so this idea of this inner healing intelligence is basically just this instruction to trust the process, to open up, even if it doesn't make conscious sense. So that has been something that has been used as one of the attacks against what we're doing. This idea that this is this spiritual, mystical concept of this inner healing intelligence. It's never been scientifically proven, and therefore somehow or other it's a whole dubious idea, and everything that we do is based on this dubious idea that's not really scientifically valid or never has been scientifically proved. So the important point when you try to work with the FDA to make a drug into a medicine is that you have to demonstrate safety and efficacy, but you don't have to have mechanism of action. You don't really have to know how the drug works. There's a lot of drugs that are approved that we don't even really know how they work at all anyway. So this idea of the inner healing intelligence is kind of a mechanism of action, kind of a thought. It's not necessary that it be, quote, scientifically demonstrated and validated. It's just this encouragement to open up to frightening things, to beautiful things, but just to explore what's in. So I would say that line of attack that has been leveled against us about this inner healing intelligence, I think, is misplaced because it's not directly related to either the therapeutic outcome measures, the independent raters, what the patients have to say. So there's this other sort of line of attack, I would say, that has been that we're a therapy cult. And you heard Brian talk a little bit about cults. And so this idea that we're a therapy cult and you have to believe in this non-scientific concept of inner healing intelligence, and if you don't believe in it, then you can't be part of it, and you can't challenge it. So that's been a kind of exaggerated critique that, in fact, in some of the critiques, I was called the therapy cult leader on par with Scientology and NXIVM, which just shows you a little bit like, and my response was, where's all my Rolls Royces? You know, where's all my bank accounts? You know, where's all the people that don't challenge me? So I think it was just this exaggerated kind of a thing, but it's used on this spiritual mystical sort of line of attack. Now, there's a whole other area of experiences, though, that do seem beyond our more traditional understanding of therapy, where you talk about what happened in your life, you talk about what happened in your childhood. And there's Stan Grof, who's been my mentor and the mentor for a lot of the actual psychedelic researchers, and he helped start transpersonal psychology. That this concept that there's sort of three general areas. He would say the first he called Freudian, which is just, but Freud, I think of kind of like Columbus. You know, he discovered the continent, but he mapped it all wrong based on his own cultural context, which he overgeneralized. So there's biographical, basically. We don't even need to say Freudian. Biographical stuff that happens. Then he talked about birth trauma, that we all go through this process of birth, and it's challenging. Many people, both mothers and children, die in childbirth, and it feels like you're uncertain. And so this concept that people can have memories of what happened during their birth seems to be validated by a lot of what people report. And then also what he called this realm of transpersonal experiences, and that's this beyond ego states. It can include various archetypes, various confrontations with death, sort of information that you pick up beyond the five senses. And so I'd say from all of these kind of experiences, particularly these more mystical, spiritual, transpersonal experiences, what we like to say is that something can be useful without being true. That's how I think about astrology. I think that astrology can be useful, but it doesn't have to be true. This is a slight digression, but I had this discussion with Stan Grof, where he does talk about astrology, and I said, you know, I've learned everything so much from you, but I really can't figure out this astrology. It doesn't make sense for me. And so I talked about the discovery of Pluto, and now that's a new planet. Okay, so how do you figure out what this new planet means in this astrological situation that's been developing for thousands of years? Well, the discovery of Pluto was more or less around the same time as, quote, the discovery by Freud of the unconscious. So then we map onto Pluto what we now think about our more sophisticated understanding of the psyche, And so then we've got this map, and I personally believe that if we were to just, I did a astrological reading with Rick Tarnas before I did a big LSD trip. And I found it to be useful, but not necessarily true. And I think if he would have picked any other birth date and I would have given him a fake birth date, it still would have been a really productive discussion. All right, so the way that we approach these experiences in therapy is that they're real to the person that's experiencing them. And the emotions are real, and we want them to explore as much as possible. But we don't have to buy into this is your actual memory of you being abused when you were 2 years old by your father or something like that. That may be true, it may not be true, but it's not essential from a therapeutic perspective that we say it is true. It becomes a challenge when people want to...
I don't have my blinking light, but you're at about time, but you can finish
your
thought.
I'll just say it becomes a challenge when people want to take what they experienced into the legal field. Like, I want to charge this person with abuse, or I want to, and there's a really interesting book called The Tell that's going to be released very soon, and it's about a woman who went through MDMA therapy and remembered abuse that she had put out of her mind completely, and then it was this whole effort to try to see, did it really happen or not? And so, again, this idea from a therapeutic point of view, it doesn't really matter.
Thank you so much. And Rick didn't quite introduce himself, but he's the founder and longtime executive director of the Multidisciplinary Association for Psychedelic Studies, or MAPS. And thank you so much for that terrific talk. No, it's okay. I just want to make sure everyone knows who you are. And our next speaker will
Other
be...
than countercultural
Well, no,
criminal.
yeah, I mean, they have the important information about how you see yourself. But in case, people new to psychedelics in the audience, which we're happy to have you. Reverend Dr. Jamie Clark-Souls,
thank you.
Take it away.
Thank you, and thank you, Rick. Well, good afternoon, everyone. I am honored to be on this panel with these especially esteemed colleagues and to be part of the whole Pulse initiative itself. So just to quickly introduce myself, so I am professor of New Testament at Perkins School of Theology at Southern Methodist University in Dallas. One of my delightful students is here right now. So I'm an ordained Baptist minister in the American Baptist tradition, and of course my job as a seminary professor is to devote attention to the academic, professional, and spiritual formation of my students and those to whom they will minister upon graduation, whether as clergy, chaplains, or lay leaders. I am a New Testament scholar whose current research focuses on the intersection of psychedelics and Christianity, with special attention to sacred texts. I recently published an essay titled Psychedelics, the Bible, and the Divine in the open access journal Religions, if you're interested in that. So my work in the area of psychedelics aims to build bridges between spirituality, and especially Christianity, because that's my lane, and other areas such as medicine and law. I am on the Emory Center. I'm a field scholar for the Emory Center for Psychedelics and Spirituality, which is that intersection of medicine and law. I've also done various psychedelic-assisted therapy training programs as well. I should mention for the Emory Center, they actually have a really important 2023 essay that came out that I actually believe established the CERT acronym. Is that right, Jay? Yeah, so the Spiritual, Existential, Religious, or Theological. And I'm also part of the Transforming Chaplaincy Network. And I know Paul Griffiths is here, and there's going to be a big conference tomorrow you should all come to. So the chaplains are represented in the room as well. So from its inception, the Christian tradition has housed non-ordinary embodied mystical experiences and is replete with resources for exploring them. Christianity is based upon the claim that people personally encountered, and still do, a dead man, Jesus, who had been executed by the Roman government in an act of capital punishment, who was then resurrected, and who called them to a particular way of life that we now call Christian. In other words, Christianity itself is fundamentally based upon mystical experiences had by the first followers of Jesus. Easter, the most important day and season in the Christian liturgical calendar, celebrates these resurrection encounters. And in fact, the New Testament says that Jesus appeared to over 500 people. Sometimes the mystical experiences are individual, and sometimes they are communal. And we can go into 1 Corinthians 15 if you want to, because I'd love to, but trust me, it's in there. So again, I'd also be very happy to share all kinds of examples from the Bible, from the individual to the communal. If I quizzed you, you would probably come up with Paul's Damascus Road experience, or his experience in what he calls the third heaven, or paradise, or what about Jesus's transfiguration, or what about the entire book of Revelation? The Christian church, broadly construed, however, is arguably largely unaware of or uninvolved with the so-called psychedelic renaissance. It is ignorant of the medical therapeutic trajectory, which is regularly presented in mainstream news media, and even more so regarding movements in the larger culture involving access to and use of psychedelics beyond medical contexts. Part of my own vocation is to help the church participate intelligently, skillfully, ethically, and meaningfully with the ways psychedelics and the Christian tradition connect or not, so that the church can better serve those seeking healing and spiritual growth. I'm currently writing a book due this year called Psychedelics and Soul Care, What Christians Need to Know. There are at least 4 areas that the church needs to consider, and a number of them intersect with the legal sphere. First, we must understand the medical therapeutic context. Psychedelics are bringing healing to people suffering, as we know, from a variety of ailments. So how does the church engage this fact, and what is its responsibility in terms of, for example, pastoral care considerations and denominational policies? Second, while psychedelics remain largely illegal in the U.S., their legal status is currently under review in many states and has already changed in some. As they become decriminalized and legal, more people will have access. Thus, we need to consider those Christians who will seek to experience psychedelics in individual or group settings for purposes of spiritual formation. The Christian Bible, from Genesis to Revelation, narrates mystical experiences and even various induction techniques to invite them. Thus, when contemporary Christians have psychedelic mystical experiences, whether in the context of medical treatment or intentional spiritual formation practices, they stand in a long line of religious ancestors who have traveled this terrain. My argument in the book will focus not on whether our ancestors ingested psychedelics, so Brian has already done that in his book, but rather upon the ways that the non-ordinary experiences in the Bible might be generative for those preparing for or integrating psychedelic sessions. Christianity provides one time-tested container for meaning-making. Third, there are many justice issues to be addressed. This includes right relationship with the earth, from which these plant medicines come, as well as right relationships with Indigenous and First Nations or Native American people who have a much longer history with these medicines, especially in sacred communal settings. There are, of course, accessibility issues, especially with respect to people of color. Often those suffering the most from societal and political oppression and generational trauma are those least afforded legal access, but most harshly punished if caught accessing these medicines in other ways. Fourth, as these medicines become more widely accessed, it is imperative that the church participate in harm reduction efforts. These are powerful substances, and abundant caution is in order. The church needs to be equipped to advise those considering a psychedelic session and those who have already had the experience. In sum, the church is called to serve those in clinical contexts, those outside the church, those in the church who have already had psychedelic experiences, and those considering it. To serve people, it must first become educated and reflect carefully on the topic rather than rely on mere impressions, anecdotal evidence, or outdated information. So I spoke on NPR a while back on the weekend edition about psychedelic chaplaincy, since I'm, again, involved in this work of setting standards, systems of accountability, et cetera. So a couple months later, I was heading to my pew at church, and I was wrangling my then 3- and 2-year-old grandchildren when an older member of my church, older member of my church, approached me. I will not define that age. She approached me and asked if she could speak to me after church. So I assumed she was going to ask me to be a deacon, so I spent really the entire service making a case in my own mind for how I was going to gently break it to her that I'd really love to, but I simply can't be a deacon right now due to other obligations. So I found her after church and was ready fully ready with my defense. And to my surprise, what she said is this: I heard you on NPR, and I was wondering if you could guide me on a psilocybin journey. I also think my spouse is depressed, so could you guide them? And also, do you think our pastor has done psychedelics or knows anything about it? I told her we needed a little more time to unpack all that because, in fact, the nursery workers were wanting to go home, and promised to schedule a coffee. I also promptly informed my pastor, without revealing confidences, that this is exactly why clergy need to get informed. This is a retired professor, former chair of our deacons, right? Not a purple-haired teenager caught up in the energy of a rave, which, by the way, is its own meaningful spiritual experience for those in that community, right? So then I was invited to do a Dallas-wide lunch and learn talk at my church, Royal Lane Baptist Church, a couple of months ago, and it was really well attended. I was also then invited to speak at my seminary during our community hour at Perkins, which is known as CHAP. And I called it Psychedelics and Soul Care, what churches and seminaries need to know. It was the most highly attended CHAP in recent memory, and the room could not hold everyone. Faculty, staff, and students attended. The conversation was very lively, and the reactions and questions were wide-ranging. Everybody agreed we needed a lot more time to talk about all of this, and the students asked for a formal semester-long course. Some people had already had their own experiences. One student said he's fine with the medicines used therapeutically, but not for spiritual formation purposes. He raised an off-stated complaint. Having a mystical experience that way is cheating. The Bible tells you have to work long and hard in a disciplined way to get an experience like that. One of my really brilliant Greek students asked, simply out of curiosity, how all of this relates to what the Bible says about pharmakeia. We also discussed how psychedelics are being used to treat crippling end-of-life distress that Rick referred to. I shared with students about how some Christians, people don't seem to know this is happening, how some Christians are developing retreats tied to Christian liturgical traditions and rituals, for instance, around Holy Week. A number of students wanted to know how they could get training to be a psychedelic chaplain. One student was there who has a background in addiction counseling and was unaware that these medicines are being used for treating addiction. She was very confused about how a drug could be used to treat a drug addiction. Of course, there were concerns raised about opening oneself to malevolent entities or participating in sorcery. And then, as always happens, people want to know how they too could have a legal experience, psychedelic experience, and that's partially because I mentioned that I was in the Johns Hopkins Religious Leaders Study, so I was able to have a legal experience. So given the range from ignorance, interest, support, and opposition reflected in those comments, I would like to have an actual data on what Christians in America think so that I can resource them well. I think it would also be helpful for those interested in the legal angle to know what Christians actually think. So at the Emory Center, Jay Michelson is on this as well. We just got IRB approval to conduct a small mixed method study of Christian clergy, about 25. So that's small enough to help me before my book deadline. But within the next 18 months, we're going to do a study of 1,000 to 1,500 Christians. So stay tuned. So concluding, I want to name a couple of connections to legal questions. So Christians are using psychedelics for medical therapeutic reasons, and more will do so as the therapies become more widely available. Christians are using psychedelics for spiritual formation experiences set within a Christian container, and more are hoping to, including those who cannot afford expensive travel to do so. There has been an explosion of interest in direct embodied religious experience. In much of American Christianity, particularly mainline white Protestantism, the body does not figure positively as an avenue for knowing and experiencing God. So Descartes declared, "I think, therefore I am." But what about the senses? I see, hear, touch, taste, and smell. Therefore I am. Or what about the emotions? I love, hate, fear, rejoice, grieve, exult. Therefore I am. Or what about this? I imagine. Therefore I am. Nope, none of that. I think, therefore I am. And this thinking is always done in words, so we have become cognocentric and logocentric. Bodies, the emotions, the senses are irrelevant at best and at worst to be subdued, since they are bound to lead us away from true religion. But more and more Christians, Jews, and Muslims are interested in reconnecting with embodied religious experience and would like legal access to psychedelics that might facilitate that. Justice issues, and here's a question. So Bill Richards was one of my guides. If you all are familiar with him, he wrote a book called Sacred Knowledge. He's kind of been at this a really long time. And so we had a conversation recently about me being a seminary professor and my vocation. Anyway, we asked this question: what if every seminary student for whom it was appropriate had the chance to have this experience before graduating, since they are actually in the business of traversing spiritual soul terrain? Finally, justice issues, including accessibility. As always, we need to pay attention to who has access to these resources for medical and spiritual purposes. As Houston Smith famously said, everybody in the room probably knows this, a religious experience does not constitute a religious life. So if you've had this experience, the question becomes, what are the fruits of those experiences? And if the fruits of that experience is not an ethical life, we have to question it, right? So do these experiences lead to justice, compassion, and service? So I would argue for all of us here today, if our own work and experiences do not lead to these virtues, they should be questioned. Thank you.
Perfect. John, wherever you're comfortable.
Sorry, I'm a professor. That's the
No,
professor in me. I'm like, I have to have a lectern.
No, I'm with you. Incredible.
Hi, my name is John Rapp, and I'm a trial lawyer from Seattle, Washington. Pretty new to all this. Brian's book, Brian Muraresku, came out in 2020, which is when we started working on the Seattle Decrim Nature Statute resolution. And actually, I'll talk at the end, if I get a little chance, about the resurrection of or restoration of the Eleusinian mysteries, which is going on right now in Seattle, outside of Seattle. There's a quote from a professor here at Harvard Law School years ago. He said, "There will never be a Nobel Prize in law because it's the only profession where you get points for showing that someone thought of your idea first." And that makes it very hard for a practicing trial lawyer like myself to advise a lot of my clients, because we would need maybe half an hour to do a quick review of the major cases and statutes in this area. There just isn't that much. So what I'm going to share with you this morning is, or this afternoon, is kind of what it looks like to be on the ground dealing with, many of my clients are 10, 12, 20 people, don't have any money, among other things. I have some that are in the 1 to 200 member range that are, quite, let's say, more solid cases. They have time to spend. They have time to help me put together the materials that they need in case they're ever in trouble with the DEA, for example. And then I also have a client who's got 123,000 members, the largest single-site church in the country. But of course, some of its critics of the client, and sometimes of me, is that this is really just a dispensary. This is just a drug source with a thin veneer of religiosity. I'll talk about that in a minute as well. I did want to say real quickly, though, some other resources, and I'll try to mention more of these at the end, but tomorrow is a program being organized by Jeff Bro, who's done a lot with novel psychedelic churches. In other words, ones without a long lineage, typically an indigenous lineage. My church, the Sacred Garden Community, happens to be one of those. That's going on tomorrow. Jay Michelson, who's on the Pulse panel with me, is also putting on a 2-day program in March 5th and 6th, on the intersection of psychedelics with Judaism and Christianity, which I highly recommend. I'll be back for that as well. I also wanted to thank the rest of the Pulse panel, including Jamie and Victoria, and the tribune of the people here. A lot of you probably don't know, but this guy was out there pushing for MDMA when some of us were much younger and some of you probably weren't born. So this guy has definitely made his stripes. Also wanted to thank Glenn Cohen, Mason Marks, Victoria, again, Laura Chong, and Susanna Baruch for their help in making all this happen with the Pulse panel and Poplar and today's event. Just a couple of quick words about terminology. and this isn't, not everyone would agree on this, but when I talk about psychedelics, I'm talking about all use of these molecules. When I talk about entheogenic use, I'm talking specifically about their religious use. Not everyone does that. I'm not saying it's the only way. The other thing, for those of us who practice in the religious area a lot, we get tired of saying a psychedelic church for religious purposes or an entheogenic church, so I just say entheist, right? So not everybody does that, but it's nice and short. Most people know what I'm talking about. So my job is to protect and connect psychonauts, and in particular entheonauts. Why do I add that second part, connect? I'm a lawyer. That's not typically my job. But this movement is very small. And particularly when you look at the religious side of it, it's even smaller yet. And I do think we have power in numbers. So I end up doing a lot of that kind of work. Also, I want you to understand, since I am a practicing lawyer, I am a lawyer. I think I'm a decent lawyer, but I'm not your lawyer. So please don't go out and set up a entheist church based on what you happen to hear over the next 10 minutes or so. Also, for those of you who are interested in the ethical side of these things, there's a lot of ethics that if I have time, I'll get into about taking proper cognizance of indigenous practice and traditions of reciprocity. But in the first instance, as a lawyer, I need to keep my license if I'm going to help anybody. And the law in particular gives us, A, the right to argue for legal reform, which I do. I don't think the law should be the way it is right now. When Brian Muraresku says, I don't want religion, I want a global ritual. A global ritual at this point is not covered by RFRA, in my opinion. Others may disagree with that. Spiritual, but not religious, which is 49% of the American adult population, is not covered. So what does that mean? I end up having to talk to a lot of my clients who don't really like organized religion about how to become one. And I'll talk some more in a minute about how difficult that can be. Just again, for people to get the basic framework, there's only two legal ways to use psychedelics in the United States. One is with a doctor. Ketamine is available legally, or a clinical trial. Besides that, the only other legal way to use it is if you're part of a religion. So that's why, and particularly with some of the stuff that Mr. Doblin has gone through recently, I think as a matter of exclusion of alternatives with the FDA, or as much as I admire Brian, all this about slow and careful, and you know, there are people out there dying of opiate addiction, people are suicidal every day, people that have gone to war and served the rest of us who can't get up every morning without wanting to kill themselves. I don't necessarily think we have forever. And in the meantime, while the FDA and others go their way, the churches are really trying to take up the slack to the extent we can. Also, people talk a lot about decrim. Just so you know, the federal government's laws cannot be nullified by a state or a local jurisdiction. So when you talk about state legal, that's all it is. Colorado and Oregon has nothing to do with federal law. Also, the decrim that you've heard a lot about is typically at the local level, usually a city like Washington, D.C., Seattle, Oakland, a few cities here in Massachusetts. Again, they don't have the ability to nullify a state law or a federal law, but since in a jurisdiction, for example, like Seattle, the county has almost no police. Most of the police in King County work for the Seattle Police Department. So if the Seattle City Council says, as it did, they get to spend no time and no money arresting people, that it doesn't even constitute probable cause, practically speaking, that makes a big difference. And if you're in a decrim city, in a decrim county, and you're doing it for sincere religious purposes, that's about as protected as you can get in the United States at this point. So I'll get into the legal tests in just a minute, but one way to think of this is kind of a continuum or a spectrum. As much as I might like to say it is, a Grateful Dead concert is not protectable legally. Taking a bunch of drugs with your friends and going out and hiking, also not protected. Therapy, not protected at all. In fact, there are many cases, not many, but in this context, there are several cases that distinguish true religious use from therapeutic use. So for example, when one of my clients came in recently and had on his website that you can expect after this psychedelic weekend retreat that you'll experience more chillness, right? I think that's probably true. I think it's a good thing, but it doesn't help the religious claim. Besides churches, the other group that I represent a lot of are therapists and even some MDs. There are a surprising number of MDs and nurses around the country engaged in underground ceremonies. Most of them also have licenses, and that's where a big part of the risk comes from. The truth is there's not a lot I can do for them. You know, if you want to put your above ground license at risk by doing underground ceremonies, I can give you some idea about the likely consequences of that, but I can't actually help you structure that in a perfectly legal way. So practically speaking, what we end up with the atheist churches is a distinction between proactivity and passivity. If we're proactive, we can file a petition with the DEA. So far, there have been 24, 25 filed. The longest one that's been pending is almost 9 years. The DEA at this point has never once granted a petition without litigation. So at this point, we have 2 peyote churches and 3 ayahuasca churches, the latest one being agreed to last year, about the same time, actually, that the GAO told the DEA that they need to get their act together. So far, the DEA is acting just like they've always acted, which is just waiting for them to get around to it. And one of their requirements is that in order to meet the definitions, the requirements for a petition to be granted, you have to suspend practice. I mean, these are religions. What would happen if somebody said you can't have communion for 8 years until we figure out whether you have the right to? Within the law, what we're looking for is a balance between the burden. A lot of my clients are very confused. The government has the right to burden you. They just don't have the right to unreasonably burden you. And they also have to look for a feasible alternative if there is one. This is the standard of strict scrutiny that was created after the 1990 Smith decision that turned down a psychedelic church in 1993. RFRA, the Religious Freedom Restoration Act, was passed specifically to help a psychedelic church, even though now it's largely being used in some fairly conservative causes and resulted in decisions like Hobby Lobby, which, believe it or not, actually helped the psychedelic churches, even though I'm pretty sure the litigants were not looking to do that. In terms of what I spend my time on with my clients, we make a distinction between safety and sincerity. Whether you're doing it for the DEA or whether you're just waiting to be arrested, what you need to be able to do is to demonstrate that your safety approach is at least as good as the DEA's would be. What does that mean? It means to some extent protecting the members. The way the law works now, no matter how traditional, indigenous, whatever your history, the government still claims the right to keep you from hurting yourself. And that's not such a bad thing. There was just a group last year that suffered a $15 million verdict. The Soul Quest case had to do with a combination of ayahuasca and combo. Fairly simple situation of a particular kind of extreme dehydration. Not that hard to deal with, but there was nobody medical on site. The other safety that's brought up a lot is anti-diversion, basically keeping it out of the hands of kids. Very similar to what's happened in the cannabis space. So what I talk to my clients about then with respect to the second prongs, we have safety, then we have sincerity. And it needs to be sincere intent, but it also needs to be sincere religious intent. Just the fact that you think this is good for the world or everybody ought to have one of these experiences is not enough. So what the courts look at is the difference between pretext and practice, right? So my client with 120-some thousand members thought, well, gee, how do you really shepherd those people? Do you actually have ceremonies, or is it just, are you feeling, religious today and would like some mushrooms, okay? And how you demonstrate that, I think, is both with what is said and also with what is done. So with my clients, we start with a storyline. Believe it or not, even some of the strangest churches out there, the founder typically has a good storyline, a sincere storyline about what happened with them. That's the first half. The other half is what's actually done. And if you have a lot of parishioners who mostly are just taking drugs, that's not going to work well with the DEA. On the other hand, we haven't been able to talk to the DEA, so it's a little irrelevant at this point. Just to give you a quick rundown of the tests that the courts look at, there are three main tests for what constitutes a sincere religion in the US. One is a very old-time definition from the IRS code, 14 different points, two of which are have a seminary, have Sunday school, right? Seriously, we have to have Sunday school in order to be a true religion. Then there's a second one from the Ninth Circuit called the Quintans case, and it has 5 elements that basically talk about what you need to avoid. Ad hoc beliefs, lack of ceremonies, too much quantity, use of other illegal drugs, and evidence of commerce or too much commerce. The most important test is called the United States versus Meyer. It's another 5-point test, except the 5th one contains 11 elements, so it's basically a 16-part test. And that one talks about what to do. But some of these things are very strange. So for example, if you look at the case law, personal works. If it's a personal belief, that works. Merely personal does not work. That's a different case. An isolated teaching doesn't work. Personal preference doesn't work. But if you have comprehensive beliefs, you do mission work, you have special diets, you have holidays, etc., those things do count. And that's also a big part of my practice. Essentially, I had no idea after decades as a commercial litigator that I was going to end up writing Bibles, essentially. But that's a lot of what I do. The court in Myers also added something that is often not focused on. The court said another factor that could have been included on the list of Orthodox religions is dogmatism and intolerance. So not all these things are
About at time.
Okay, I'll just finish up real quick.
Thank you.
So I wanted to read something that I think is quite remarkable. Jay and I have talked about this. It's often missed in the literature on the law here. This is from the Myers case. Had Myers asserted that the Church of Marijuana was a Christian sect and that his beliefs were related to Christianity, this court probably would have been compelled to conclude that his beliefs were religious. Under these hypothetical circumstances, Meyer would have been able to fit his beliefs into a tradition that is indisputably religious under American law. If Myers had linked his beliefs to Christianity, the court could not have inquired into the orthodox or propriety of his beliefs, no matter how foreign they might be to the Christian tradition. Had Myers sincerely made such a connection, he would have been able to purchase religious status for his beliefs by coattailing on Christianity. Unfortunately, he made no such connection. To me, that's just an invitation to clients to lie. And I don't think the law should be that way. I think it will change. I've got some additional thoughts, but I'll add those later. Thanks for your attention.
Yeah, such a terrific panel, and I hope those additional thoughts will come up during our Q&A. So you should all be thinking of your questions, but I'm going to start with a question for our 3 panelists, which is to ask them to explore the connections between what they spoke about and what other panelists spoke about. So after listening to each other, what themes or insights really resonated with you from each other? So whoever wants to jump in.
Okay, well, maybe I'll start. So for Jamie, what you were talking about, one of the things that I thought you said was very courageous, but also kind of contradicted by what you were saying, is that people going to a rave can have a very spiritual experience, a very communal spiritual experience. So just going to Burning Man doesn't necessarily get you to win a case. I should say that Marion Goodell, who's the CEO of Burning Man, will be here speaking tomorrow at the Divinity School. The other thing that really struck me, Jamie, about what you're saying is that it was the church that wiped out the Eleusinian mysteries. And so what you're doing, I think, is so critically important to try to bring back sort of psychedelic spirituality into religion. But it was the Catholic Church that wiped out the Eleusinian mysteries because it was a competition between somebody who would, this whole group that would have direct experiences, and then the church wanting to be the intermediary. So it was kind of a classic power game. And the church has, over the millennium and a half or so, been responsible for the suppression of psychedelics wherever they went. The conquistadors, the first people they wanted to kill, were the shamans, because they were often the core of the community. And so now, I just was in Mexico City, where Maria Sabina gave mushrooms to Gordon Wasson and then Valentina, his wife, but they still don't even have research into psilocybin. So we have this situation where this idea of direct experience, and what you talked about dogmatism, I thought is the thing about a church. So how do we get to this point where you can have these direct experiences, which often do turn people from more literal fundamentalists to more spiritual, ecumenical, kind of, more spiritual, less religious kind of thing. But still, they tend not to leave their church. And I think maybe you're probably an example of a lot of the people that were in the psilocybin religious leaders studies that had these experiences, but then didn't leave their communities and tried to do that. The thing, John, that you're saying, one of the things that struck me is we know about the martial art called Aikido. And so I think what you're doing is like a classic example of the Aikido strategy. So the idea in Aikido is that you use the momentum of the opponent against them. You don't confront it directly, but you try to help them sort of experience the consequences of their own actions. And so what we have now is the rise of the religious right, the Hobby Lobby case, that you can discriminate against people based on your religion. And so the reason that we have a lot of these hundreds now, I believe, of psychedelic churches is because there has been very little enforcement, because of the fear is that the courts might actually say some of this is legit, and then you have much more proliferation of these churches. So it's like using this religious right, religion, you can pretty much do anything you want now to try to protect things. The other thing that I just wanted to comment on was about whether you are the safety arguments that you made about how they want to see that you prevent kids from getting it. But that is not the way all of the Native American church works. It's not the way the ayahuasca churches use their ideas. I went to a Navajo peyote ceremony, Native American church peyote ceremony on the Navajo reservation, and one of the Navajo men brought his 9-year-old son to take peyote and spend the night with us. And he didn't quite take as much peyote as the rest of us did, but he was there. And it's the same in the ayahuasca churches. So I think one of the fundamental problems, I would say, the disasters of the drug war, is it gets in the way of parents educating their children the way they would like to do it, because it's all criminalized. Even in this case, 23 states in America permit parents to give alcohol to their kids, over trumping the idea of prohibition against use by minors, but they've lodged it in the family. So that's just an idea I'd like to see. Can we expand that idea of parents being able to educate their children? Yeah, and then we adopt, again, this Aikido idea. Now we're the family values. And families, rather than the government, should be the one that tells how you do it. So I think that's kind of a misunderstanding of what safety means, is that you prevent it from getting to kids.
Well, that being said, Rick, I'm not looking for a client right now who's giving ayahuasca to their teenage kids. I'm not saying you're incorrect at all. I'm just saying that, we've had so little help from the federal government that we're trying to stay out of some of those more edgy cases, I guess.
Yeah, John, do you want to jump in with what you've learned from the other panelists? Maybe pull the mic over so everyone can.
Actually, I took a couple of notes. Let me go through those if you don't mind, then I'll respond to that.
Yeah.
You want to go next, Jamie?
Yeah, here, Jamie.
Sure. So, so thank you, Rick, for your comments. And yes, I think you're kind of hinting at the whole issue of colonialism and the church's role in colonialism, not just here, but on a lot of things. So I think that's very important to acknowledge. And that's when I talk about the one part of the book that's on justice issues, of course, that's that's part of it. So thank you for that, that insight. So in terms of Rick's talk, when the conversation about inner healing intelligence, you know, I'm sitting here as a Christian, a biblical scholar. What's interesting to me, and I speak to therapists a lot to try to actually get them to imagine that when clients experience things that are supernatural, yes, don't dismiss it and actually consider that it might even be true. But that's another story. So there's this language of inner healing intelligence when I'm speaking to the Cleveland Clinic. I don't know how I feel about this. I'd love to hear input. But when I hear this kind of language, I wonder how much that overlaps with the Christian notion of the Holy Spirit. So in Christianity, you have this notion of the Holy Spirit that does dwell inside you. And the kind of, you're talking about can't be seen under a microscope and quantified. And so in John chapter 3, there's this thing about the Spirit blows where it wills. You don't know where it comes from, whether it's going. That's inherent in the beautiful part of it. So this whole debate between what you can put under a microscope and what makes something real, I think is very important. One question I have for you based on that, since there are these overlaps and we tend to be siloed. So from Rick, I would like to know, what is one collaboration that is not currently happening that you would like to see happen that would be fruitful? That's a question I have for you. And then for John, thank you so much for your presentation. I learned a lot in it. I definitely want to hear, we can talk offline, I definitely want to hear about the writing Bibles. Definitely need to hear more about that. And it does, in all seriousness, what makes a sacred text a sacred text. I'm curious about that because that's what I do for a living. And it also raises the issue for me, even your comment about the tacking on to Christianity. You know, does how old something is factor in? So like you write this Bible and it's brand new yesterday. Does it have to have a certain longevity in order to be a more forceful argument? And is that also true beyond the Bibles? Like, how does being old help? And what counts as, what's the minimum of oldness to help?
Well, it helps for lawyers, that's for sure. I mean, we cite cases all the time that are 30, 40, 50 years old, sometimes even centuries old. I think most academics and most other disciplines, if you did that all the time, you'd be thought to have not done your homework. A long lineage does help, no question about that. I think that's unfair in some ways. The church I belong to, the Sacred Garden community, we're trying to have the best of both worlds. We've created a model, kind of like, I call it like the Baha'i of the plant. So we have a dozen entheogens as opposed to most psychedelic churches that have one or two. That also makes it harder. There's some judges have mentioned that having a single sacrament and having a long lineage in that sacrament is a help. I think it probably is. One of the things, having this one large client, I've gotten to hire some experts that some of you may know, Gordon Melton and Sam Brunson, and Jim Richardson, Cole Durham at BYU of all places. BYU does a real big job trying to help with all kinds of groups that are perceived badly on the so-called fringes. So that helps. I've really gotten excited watching Jeff Bro's project with novel therapeutic churches, which is defined as exactly those that don't have a long lineage. I think the government's view, probably at all levels, state, federal, local, is, nice try, right? But I don't think that's the end of the matter, and we certainly expect to win at least some of these cases if and when we decide to go for a petition or one of our leaders gets arrested. By the way, I wanted to say two quick things just at a factual matter. I think it was you, Rick, maybe mentioned we don't really know how many entheogenic churches there are, and that's true, we don't. But I wanted to let everybody know, Gordon Melton and I just worked on this directory. It's called Entheogenic Churches and Religious Bodies in the United States. It was literally posted yesterday on my law firm website. And we're also trying to get all the creeds from as many churches as we want. And there really are quite a few more churches and religious organizations than I expected. The other thing I was going to mention is that people get a little confused about the seizures. The vast majority of the seizures in the United States are A, of ayahuasca tea, typically from South America, and B, they're not done by the DEA, they're done by Customs and Border Control. It just falls into their lap. So because of that, there's been more litigation over ayahuasca, but the truth is it's not the primary issue. I mean, probably if you had to pick one, it would be mushrooms or cannabis. Did that answer your question? Okay.
You want to respond to Jamie's question, and then we'll let John.
So, yeah.
Lots of good, I love it.
Okay. So this idea of a collaboration. So in 1983, I read this book, New Genesis, Shaping a Global Spirituality, and it was by the Assistant Secretary General of the UN. And what he was saying is that we have the United Nations to presumably mediate conflicts between countries, but a lot of the conflicts are actually religious-based, and we need to understand this global spirituality, how we're all in it together in a way. And he had a picture of the Earth from space on the cover of the book. Global spirituality doesn't mean that you don't have all the individual religions. It does the same way that we have, the idea was that languages, that religion are like languages, and we have all these different ways to express ourselves, but we don't say French is better than German and German is better than English. They all have their different flavors. So I proposed an experiment back then with him that would be a great collaboration. So it would be to take people that were in the seminaries, as Bill Richards suggested, but from a bunch of different religions, and then divide them up into those ones that get supplemented with psychedelics and those that don't. And then you, over time, see how those people that had psychedelics differ from those that didn't. But then what you're doing is you compare the visions that they have, the content of their experiences, with the people from the other religious contexts. And the goal is to see, first off, I'm sure it's the case that people that have from one particular religion often have symbols of other religions. So the goal of this, is there a universal spirituality, common mystical experience at the core of all the other different religions, or is that not the case? So that's the kind of collaboration is. So you compare the visions that they have to the theology of their own religion, but also to all the others. And could we understand one day that we would move from fundamentalism more to mysticism, and that there would be, like, I love that you talked about the Baha'i. Yeah. You know, the Baha'i religion is very much under suppression in a lot of the Muslims, but it has all these different prophets. So what can we do both with scientific tools to look at spiritual experiences from people of a bunch of different religions?
If I could say real quick, you know, in my church, one of the things that we do are holidays, and one of my jobs as a leader in the church is to come up with holidays that seem to express sort of the uniqueness of the church. And your birthday is one of the holidays.
Well, I would love to come celebrate with you.
Please, come down.
Incredible.
November 30th.
I almost want to leave it at that, but we are going to open it up for Q&A, unless, John, you wanted to offer.
I just had one question I thought I would put to Jamie, because, you know, you're actually a minister as well, right? And this really is a question. I have no view on this. I do not know what to do about it. If you take all the claims out in the psychedelic movement now, there's folks from medical who want certain kinds of safety. You got what you mentioned, traditional say ayahuasca ceremony, you bring the whole family, you know, and sometimes your 12-year-old is taking it with you. Then there's all the indigenous concerns and misappropriation, et cetera. How do you take account of all those without just creating a new priesthood, where suddenly now the access, which we're all trying to work for, and which, for example, Oregon has been such a failure in, they weren't trying to be a failure. Right, they were trying to provide more access, but when you add all these layers of considerations, at the end of the day, it's basically you get to have a big journey when I say so. And that doesn't seem to me to be where we want to end up.
Yeah, so are you asking within an individual Christian community? Can you clarify the statement?
No, I'm saying the whole movement. I mean, there's, whether it's ethical, indigenous, somebody's trying to say you can only do
somebody's
this.
a gatekeeper.
Yeah,
yeah. We were talking about Deepak's in the room too. Yeah, we're talking about how do you, in the process of, because you have to have safety, so there has to be some kind of ground rules, and then you therefore have to have someone who enforces said shared, well, and I think the fact I'm Baptist also really influences this, because we don't have bishops, we don't have any authority outside of our own congregation, so that would be different if different Christians in the room responded to that. So that has to do with, yeah, I think having shared leadership, having represent, whoever's kind of running it, it needs to be multiple people who, where there's representation. So gender, ethnicity, sexuality, et cetera. So everyone's voice is represented and everybody is, yeah, everybody's voice is represented in saying, hey, this is getting hierarchical and there are power plays that are excluding folks. But I think a kind of democratic, we have like committees in my world. So like where everybody has a voice and there's not one person who can trump anything. But like I said, I'm Baptist, so we don't have bishops and DSs and popes, or so it's probably a different answer for me than others. Yeah.
Can I add a little something to that? Yeah, Victoria. Thanks, Jamie. One other thing, it kind of relates to your
Maybe
point
just pull
about...
the mic so that people,
sorry.
I just want to make sure everyone can hear.
Yeah, sorry about that. Yeah, it kind of relates back to this point about these indigenous practices. So, for example, when the courts distinguish between, say, therapy and religion, there are religions who have therapeutic practices.
Yeah, sure.
I mean, you know, James Dobson in the Conservative Christian Church, and people will literally only go to a therapist in some cases if they're Christian. Think of Science and Mind, science or Christian Science, which is based here in Boston. And they have these mind treatments, which sure look like a type of therapy. Then retreats is some of the courts have mentioned, oh, you just go on retreats and everybody, you know, has a good time. There are plenty of retreats in traditional churches where everybody has a good time too. So you wouldn't think that that ought to be a huge difference. But anyway, and I think from the point of view of a lot of my clients, their view is, well, we didn't call them clinical trials, but we've been working with this stuff for centuries. And you're saying you guys swing in, you know, for what, a few years now since the drug war has relaxed a little bit, and suddenly you know more than we do?
Right. Right.
Wow. Thanks again to our terrific panel. We're going to open now for some Q&A, so you've had plenty of time to think about your questions. Lisa's bringing a mic out. And I will do my best, either direct it to someone, or I'll try and direct it to someone, or we'll open it to everyone.
Great. So my question is actually for John. I mean, others can jump way in too. John, I've always been curious about, in some of the cases, the emphasis on having a physician on site in case something goes wrong. And I always thought, in some ways, that's exactly mixing the medical with, and even though the idea is you're not promoting it. So on the one hand, you cannot promote it as medical. On the other hand, it's a big plus if you have a physician there. And I wonder if you have thoughts about whether this is just a strange quirk about the way the courts have done it, or whether you think this is a persistent feature.
Well, it certainly helps the authorities, right? They feel more comfortable with it. There are issues. They tend to vary by substance. So, for example, Iboga has this long QT issue that most doctors know about, but a lot of other people don't. One of the issues I've talked about with Mason quite a bit, though, is this issue of not just risk, but comparative risk. If you start looking at some of the issues with therapist abuse, with people freaking out for one reason or another, that's a medical term, right? Freaking out. You know, are these really greater than you see in traditional therapy or other medical situations? I certainly haven't seen the evidence of that. On the other hand, as I said to begin with, you know, the government and a lot of people, I know a lot of just risk-averse people, you know, doctors, lawyers, whatever, they may be completely psychedelically naive. They didn't go do anything in college. They didn't, like you, Jamie, didn't, when you went through, you had to be completely psychedelic naive for that study.
Yeah, I had to be psychedelically naive to be in it.
And a lot of those people, when I can tell them, oh, you know, like around the Seattle area, we have about 100 MDs doing underground ceremonies, and they are starting to get investigated more because some are my clients, so that's how I know. But there are a lot of people who want that. They want to see the little thing with the blood pressure and all that, and typically those ceremonies cost more, but they kind of should, I guess.
I want to add that the FDA does not require doctors on site for clinical research. You have to have a medical screening ahead of time, and there needs to be a doctor on call, but the doctor does not need to be on site. The FDA Division of Psychiatry tried to impose that idea that there needed to be a doctor on site several years ago, and we filed a formal legal dispute with the FDA, with lawyer scientists, and they also wanted the lead persons to be MD, PhD, not just licensed to do therapy. And this was in a protocol to give MDMA to therapists as part of their training, what they said they would never approve, and we won on all 3 points. So I'd say that this idea of medical screening makes a lot of sense, particularly with other medications that might people be on, but in order, at least, I don't think that the religious use should be even stricter than what the FDA is saying for clinical trials. But then you get the question is, what kind of medical screening is there beforehand?
Yeah, and I'll just add moderator privilege, right? In some of my thinking in writing, these questions around what is religion and medicine is just kind of evidence that this is like a modern separation, right? Like historically, for most of human history, spiritual, healing, medicine, religion, like this is all the same. And so this like bifurcation that we're seeing in a modern context, I think gives rise to a lot of these issues and problems. One of the themes I think I saw throughout all of your talks. I know there's a lot of really smart people in the room with good questions, so please don't be shy.
Hi, this is a question for Jamie. Speaking of collaborations, I'm really interested in a collaboration outside of just delivering the medicine, but integration, knowing that so many people are already using them in the underground, but don't necessarily have a place to go.
Right.
So I'm curious what you could see as a collaboration maybe between, churches, established churches, and integration coaches where Sunday services, weaving that in, and there's a place to go where people can find the others. And
yeah, I think, thank you for the question. And I think, and I love the impulse of it, and I think it's really important. And this is where I think the church could actually, and other religions too, I only know, I want to speak for mine, can actually provide these kinds of services, and also for free. So especially for free. So there's accessibility for folks. We have this model a lot. Churches work closely, for instance, and I'm not at all making a comparison in terms of the substances, because this is night and day, I understand. But like with AA, and we typically work very closely and actually give free space and all of that for, almost call them integration circles, but, certainly housing that. So I love this, and I would love to hear more of that. And we also can provide, we have things like spiritual direction. So groups, I think churches could do a good job of hosting groups. And I also think they could provide individual. And so I don't know if you all are familiar with Lagare.org. There's also a Jewish one called Shefaflo with Zach Kamenetz, and Sugar Ahmed is starting a Muslim one. But anyway, Lagare.org provides spiritual directors, particularly trained. They're regular spiritual directors, but they're trained also in psychedelics. So yeah, let's think about how churches, but first the church has to even know this is a whole thing is even happening, and then also stop being stuck just in the 60s. If they know something about it, they don't know anything about all the research and all of that. So thank you for the question. It's really important, and I think a very hopeful service that could be provided by the churches.
Hi, good afternoon. Thank you. I'm Brent Richardson. I'm a fellow in bioethics at the medical school, and I'm a clinician from New Hampshire actively working on legislation, medical aid, and dying. My question for you is there any work in that interface with the use of psychedelics and medical aid and dying, and specifically some of the criticisms? I work in critical care. I also work in palliative care. Some of the criticisms in palliative care have been that medical aid and dying is going to undermine the process that can happen at the end of life with meaning making, so to speak. And I think there could be an opportunity for meaning making in the type of work that's going on in advance of medical aid and dying, if there is time. So that's my question to chew on.
Well, one of the things that we've been trying to make a point of is if you can avail yourself of medicines that will kill yourself, as far as medical aid and dying, shouldn't you also have the right to try a psychedelic to work through the emotions first so that you might want to stay alive longer? So I think we're trying to use this medical aid and dying as argument for expanding opportunities. And what just happened the other day was there's the right to try laws that are in 39 states or so that say that if you have failed on other medications, and that if something is being researched by a pharmaceutical company, you have a right to try it, and you just contact the pharmaceutical company, and the FDA is not even involved in that. And it excludes controlled substances, though. So there was a lawsuit where it just came down just the other day that now it is not the case that you can expand right to try to controlled substances. So I think it just makes that point even more. How could you possibly, in a rational society, be able to kill yourself but not use a psychedelic to try to stay alive?
Does that include class 1 DEA controlled substances?
Yes, 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 so that you cannot use psilocybin or MDMA right now with right to try.
Yeah, you can take poison, but you can't take psychedelics.
Was the Ninth Circuit?
Yeah, that was actually one of the members of my church is a doctor named Sunil Agarwal. I don't know if anybody knows that. He's one of the named plaintiffs, and one of his patients and is the other. And went to a federal district court, went to the Ninth Circuit. It's been turned down all the way along. We got one vote in the Ninth Circuit, but as a matter of law, it probably makes some sense. As a matter of practical compassion and justice, I think it makes no sense at all.
I see you.
Thank you all for being here. John, what advice would you have for someone or an organization who's looking to potentially start their own church or religious organization
Yeah.
Not
in
legal
2025?
advice. Not your lawyer.
Well, I actually work now with 4 different firms on this. The biggest one is 160, and the smallest one is 2 lawyers. And one thing I promise everybody within reason is if you call me up and you're serious about that, we'll give you 15 or 20 minutes free. More often than not, we tell people not to. I mean, if you've got lots of money and you want to have me help you write your Bible, I'm happy to do it, but you can do a lot of it yourself. And the truth is, a lot of what people want to do anyway is not so much on the federal defense, but they want to, start registering with the Secretary of State and becoming a nonprofit. And some of those things probably make sense if you're going to be accepting a bunch of money. But I'm not big on having clients who are committing what are presumptively felonies, putting their names all over different sites. So I think to answer your question, the first question is, are you actually practicing? Or is this a money-making scheme like the so-called dispensary churches? And if you're sincere, give me a call. I don't actually do a lot of this work anymore, but I have lots of very bright associates who've done a good amount of this work at this point.
I'll also just take the opportunity to pitch that tomorrow during the Divinity School Conference, John and Jamie and myself and Mason are facilitating a workshop where we're going to be thinking about how you might set up a church and how the law might ask you to view that church.
Yeah.
So
Come to the workshop.
Yeah, come to the workshop. Yep, great.
By the way, I had one more thing that just recently has become more important. If you're, I don't know what your practice is, but if you're in a practice that already has one of these existing churches, think about joining them. You don't have to have exactly the same beliefs to, for example, join the Church of the Eagle and Condor. Within reason you do, but they've already got the protection. Anyway, go ahead.
Hi, thanks so much. I have a question, I guess, also for John or for anyone. Are you aware of any ketamine churches, and if they exist? And 'cause it seems like that would be an interesting case because it's a legal substance that wouldn't need to rely on RFRA, but at the same time, I'm curious, how we'd think through that kind of case.
Yeah, I certainly know people who use ketamine for non-medical purposes. I don't know of an actual ketamine church. A ketamine church would probably run into some of the same issues with cannabis because since it's already legal, the governments, the law enforcement folks want to say, well, go do the legal thing. You don't need this. And actually, I've been feeling more and more lately, like with the hard times, for example, that Rick has had with MDMA, by a process of elimination, I think the churches are suddenly becoming a much more important avenue for this kind of care. Did that answer your question? Yeah, okay.
Yeah, and I'll just add to that, which is to say, I think some of the questions, like if we're talking about a drug, like cannabis is also Schedule 1 right now, and if it moved to Schedule 3, it would still not make it legal to use it in a church setting. If it was descheduled, the questions then kind of shift from can we use it to what are the regulations and taxes, right? I'm a tax person, so I'm thinking about taxes. But churches are tax exempt, and medical access, drugs tax exempt in certain settings. Recreational use, that's a taxed market. So when he says, or when John says, the the government will say, oh, go into the regulated market, go buy your cannabis, like churches, go buy their alcohol, but they have a tax-exempt form where they can buy that tax-exempt. So, that's where I spend my time thinking of hopefully the future where we're not fighting for the exemption, but it's more fighting about what the regulations on churches might be compared to other types of uses.
Yeah, one little data point on that too, there's actually an old case from the 1930s during Prohibition where a church came in and said, look, we can get our communion wine wherever we want. And the government won the case, said, no, it may be your sacrament, but we still need to make sure it's good wine, that it's not going to hurt anybody.
And that's a good argument for safe supply, right? Like safe supply is important.
Yeah.
And being able to cultivate at home may be also important. I'm not trying to draw lines here. Yeah.
Hi, everyone. I'm Alex. Thank you for being here. So I'm sure you're all familiar with the concept of set and setting being important for whatever experience, for whichever purpose people conceptualize that to be. So I'm curious if legal prohibition and like the specific requirements that different circuits have decided upon, what is considered to be qualifying for RFRA exemption, impacts that like mindset of participants, and if that's something that you've all found you've had to navigate in terms of achieving the effectiveness of the experience and perhaps like counteracting that as a barrier.
What a great question. Does someone want to explain set and setting in case someone in the audience doesn't know?
Well, this was actually something that Timothy Leary started talking about first. This your mindset of going into it, and then what you're expecting. So, for example, your mindset to go to Burning Man or to a rave is different potentially than if you go to a psychedelic church or you go to a therapist. And then the setting is the physical surroundings and the context that you're taking it in. And so Norman Zinberg, who was also at the Harvard Medical School, wrote Drug Set and Setting. So yeah, it's a very common concept, and I think that it makes a lot of impact. And what I've been learning more and more is that the culture, which is in a way a bigger kind of a setting, is more important in how you interpret the psychedelic experience than the experience itself, that the culture predominates. And so for me, when we think about these ayahuasca churches, particularly the União de Vegetal that went to the Supreme Court, they're called syncretic churches, so that they were only able to survive under pressure from the church. So they had to kind of merge with the church. And so you have this União de Vegetal that's homophobic, patriarchal, hierarchical, and some of their leaders aligned with Bolsonaro about destroying the Amazon. So you would think that these people that are having these psychedelic mystical experiences and they wouldn't be all of these things, but the culture that they took it within channeled how they interpreted it. And so that's kind of a damper on our idea of psychedelic experiences. Everybody will have them and change the world, and because really it's really, so I'd say not just set and setting for the specific context, but the cultural setting as well.
I'll pose maybe a final question to you, but I'm wondering how you think state legislation might factor into religious use.
I love this question. Can I?
Go for it, Victoria.
I'll start just as a moderator, because when John was speaking and he said there's only 2 ways to do it legal, right? I mean, I think maybe I'm just watching too much news, but I'm like, what federal government, right? Like what federal law? I mean, no, look, we have federal law, we have federal government for now, but states' laws matter, right? And a lot of drug crimes are prosecuted at the state level. And I spent a lot of time thinking about cannabis law, and cannabis is federally illegal, and we have a booming state-regulated industry in a majority of the country. So I think state laws matter a lot to Mason's question. I'm particularly excited about Colorado's personal use side, which for those of you who are not familiar with, legalized, decriminalized personal possession, cultivation, and social sharing, and allows for people to get remunerated, to get paid for services, including spiritual support, harm reduction services, but not for the substance themselves, which is a little legal gymnastics. We have a similar language in a bill in my state in Rhode Island that we're trying to push through the state legislature. So yes, and I will be happy to hear other perspectives on this. The federal DA exemption model and federal law matters, but there are churches in Colorado who are alerting state law enforcement that they are operating a church, and law enforcement says, great, you're not doing anything criminal under state law. And I forget who mentioned that the federal government is not that eager to enforce against these churches under state law. So to me, that state laws are very important and very exciting. I'm like very excited for the boom and the explosion of churches in these states where if the state police are okay with it and you're not importing, whoever mentioned, right? It's like Custom and Border who's seizing a lot of this at the international borders, but not a state police issue. So I'm very excited by state legislation.
Yeah, and just to add to that, the little RFRAs, which several states already have, Washington may get one pretty soon, that can be really helpful. The other thing is sourcing. I don't know how many people here actually work much with atheist churches, but you have all these rituals and things and books and Bibles and all the rest of it, and then when it's time to do the ceremony, somebody knows a guy, right? There's got to be a better way to do it than that. I just haven't figured it out yet.
Yeah.
I'll just add that there's a lot of time I've spent in my life trying to figure out that there's the law and then there's the enforcement of the law.
Amen.
And there's a lot of space in the distance, and that's where a lot of these psychedelic churches exist. And so I think the state laws make it so that there's much less likely to be federal interference, even the local laws. So, and then the space of between the law and the enforcement of the law creates kind of case studies and precedents, you could say, for expanding what the law is as well.
Can I have 1 minute whenever we're ready?
Yeah, I think we'll just, with our last few minutes, we need to wrap up a kind of a closing statement from all the speakers. Oh, wait. Do we have time for another question? Yeah, we'll take another question. I'm competing. I'm like the clock.
Thank you. Sorry, one last question. So, raver, former entheogenist myself. Now I'm a psychedelic user. Quick question. So it's more of like a quick story. So I've had my share of like good and bad, like journeys and trips with friends and stuff. And one in particular, I thought about while we were talking about like, how does someone receive like medical, psychological clearance to be able to participate like wholesomely and like receive healing and stuff in these types of ceremonies, specifically like NAC, ayahuasca and stuff like that. And so I was just wondering if there's like any like standardized medical basis or tests for to ensure like that the healthy, safety of people. Thank you.
Thank you.
Sounds like a Rick question.
Yeah, Rick.
Yeah. Well, it depends. Different drugs have different risks. So as John talked about with iboga, that has more of a risk for the heart. And then in general, the iboga clinics are operated under direct medical supervision, often with people with IVs in, just in case they have a need to stimulate their heart from it going too slow. But for MDMA, it's mostly looking at if somebody has a heart problem because it increases blood pressure. But you could go to clinicaltrials.gov, and it's all the clinical trials that are being done, and you can put in any particular psychedelic, and usually they have inclusion and exclusion criteria that will tell you what they're screening for. A lot of these are overly conservative. We used to screen out people with diabetes, and now we no longer do that. But this was just this abundance of caution, you could say. With LSD, there's really not much in the way of physical complications, but it depends on what other drugs people are taking. So a lot of drug-drug interactions make a big difference. And I would say that the difference between the classic psychedelics and MDMA is that MDMA has a little bit more risks to the body, but it's safer psychologically. And then the psychedelics tend to be a little bit safer to the body, but are more challenging psychologically. So you could also say, what are the screenings that are for, mental illness, depression, anxiety, things like that. And so that doesn't mean that you get screened out. It just means what kind of context do you need to take it in? What kind of support is necessary? So there's no one simple answer, but you can get all these inclusion, exclusion criteria stuff on clinicaltrials.gov.
Great. I think that was a great reminder that that's a resource. So we will do our brief closing statements, and then you'll all get a break.
Well, my main goal here today is not just to inform you on the law, but to tell you about the practice of entheism. Some people say this is the oldest religion in the world. That's essentially Brian Muraresku's argument, or part of it. These substances have been around a long time before the FDA was. And I do think we're in a dark time right now in our culture and our politics. I think in some limited way, the entheist churches can be like the monasteries in the Middle Ages that hold this sacred knowledge. I hope a lot of people don't realize it, but there are 2 or 3 churches around the country that are open, that you can attend, like my church. 11 o'clock every Sunday morning. If you're a DEA agent, you can still dial in just like everyone else. So if you want to see what it looks like, I forget to mention that, but people think these are all secret. Most of them are, but there's a couple that aren't. I hope if anybody's interested, you'll inquire into the new Eleusis that we're creating up in Seattle. It went on for 2,200 years in the ancient world. It's only been in evidence 39 years up here. It's a 4-day version instead of 14, and next year on the 40th anniversary, my job is to put the psychedelic back in the Kaikion cup. Wow. Also remember that 420 this year, right? Not just cannabis. 420 is actually the date of the Marsh Chapel experiment in 1962, and it happens to be on Easter this year. So if you decide you want to go to the Marsh Chapel over at Boston University and have a little plant assistance, could be quite a commemoration. Rick?
We actually have on the MAPS website the actual sermon by Howard Thurman from the Good Friday experiment from 1962. It's just, he's an absolutely compelling minister. It's really dynamic. So you might want to load that up on your phone and take it into Marsh Chapel and listen to the original Good Friday sermon. But I guess what I would like to add is we look at those movements, social change movements, more recently that have succeeded, and I would point to gay rights, gay marriage, even though they're under massive attack now. But what really helped them succeed was coming out, people coming out and saying that they were gay, and you might respect them for one or other things that they did, and you didn't know they were gay, and then they say that. So I think what we really need is a psychedelic coming out. And so I would just encourage people to feel a little bit more courage about speaking to their family members that might disagree, or speaking to your parents, or speaking to people that you work with, that we really need more people taking the risk, reputational risk more than legal risk, because you can't be a witness against yourself and there's no evidence, but you could just, I think, the more people that sort of help destigmatize and come out with their psychedelic experiences, the more this movement will get more legitimized.
Great, thank you. Yes, I think it's ironic that I'm the Baptist in the room and I'm not as evangelical. I think in some ways I am evangelical, but yeah. So no, I appreciate what you all are saying, and what I hear in the room, and I really want to affirm and uplift, is collaboration and overcoming false dichotomies, like you said, between the medical and the spiritual. People are in a lot of silos, and I think if we are all, I think everybody here is interested in the wholeness and healing of all creation in some way, shape, or form. And so I think collaborating, it's going to take all of us from our different areas, and don't have imposter syndrome, because people are like, oh, I don't have all the degrees and all the experience, right? People have goodwill coming together to get the facts straight, and to hear what the issues are, and to listen to people who are hurting or have been hurt, and put all this together to create a kind of safe, effective way forward. I think is the kind of order of business that I would like to see. So yeah, and I appreciate just appreciate this, and again, come tomorrow to the other conference too.
Yeah, and I'll just say thank you, and let's give our panelists a round of applause.
Thank you, everyone. We'll take a brief 10-minute break, and we'll start at our second panel at 1:20 sharp. Thank you so much. We have another great panel for you today. We have three experts, including David Posen, the Charles Keller Beekman Professor of Law at Columbia Law School. David teaches and writes about constitutional law, information law, drug law, nonprofit law, among other topics. And in recent years, he's had edited volumes for Columbia University Press on transparency and free speech. His excellent new book, The Constitution of the War on Drugs, was published last year, and you can get it online. It's published by Oxford University Press. You can get it online for free at ssrn.com. We also have Caroline Mala Corbin, the professor of law at the University of Miami School of Law. Her scholarship focuses on the First Amendment's speech and religion clauses, particularly their intersection with equality issues. She teaches constitutional law, First Amendment, the religion and free speech clauses, feminism, and the First Amendment and reproductive rights. And we are also fortunate to have Deepak Sarma, professor of Indian religions and philosophy, and the inaugural distinguished scholar in the public humanities at Case Western Reserve University. Deepak is the author of Classical Indian Philosophy, a reader, Hinduism, a reader, Epistemologies and the Limitations of Philosophical Inquiry, Doctrine in Madhva Vedanta, and an Introduction to Madhva Vedanta. Please welcome our panelists, and we will start with David. Welcome.
Great. I'm honored to be here. Thanks so much, Mason, for the introduction, for inviting me. Mason is one of the most exciting legal scholars in this space, easily. My role here, I understand, is to give a little bit of a tour through the legal history of constitutional challenges to psychedelic and other drug bans that were brought under the Free Exercise Clause and the Free Speech Clause of the Constitution's First Amendment. It is largely just a preview, a history of failure with a few bright spots, and I will try to close with a brief thoughts on arguments that might remain viable today. So for most of U.S. history, the Free Exercise Clause, which protects the right to religious liberty in the Constitution, was understood to have no relevance to drug bans. It was understood to protect only religious beliefs, not religious acts. And so you have the Supreme Court in the late 1800s saying things like, however free the exercise of religion may be, it must be subordinate to the criminal laws of the country. Otherwise, the clause would in effect permit every citizen to become a law unto himself. And so under that jurisprudence, claims for religious-based exemptions from drug laws or any other laws with a secular purpose were non-starters. And so when a member of the Native American Church challenged his conviction for possession of peyote in the 1920s on the ground that members of that church used peyote exclusively for sacramental purposes, the Montana Supreme Court dismissed the claim as idle without further discussion. It was clearly foreclosed by precedent. Flash forward to the 1940s. This is a potted history you're getting, but I'll try to cover a lot of ground. Flash forward to the 1940s, and the U.S. Supreme Court begins to move away from the Belief Act binary as the structuring principle in free exercise law, and to indicate that sometimes the First Amendment will require special accommodations for religion. In the 1963 case Sherbert versus Werner, the court sets out a strict scrutiny framework, according to which laws that burden people's exercise of religion have to be justified by a compelling state interest that can't be adequately achieved through less religion-restricting means. And this doctrinal shift toward making it more favorable to bring these religious liberty claims coincided with significant shifts in religious practice throughout the 1960s and 70s as part of what the Supreme Court described in 1965 as the ever-broadening understanding of the modern religious community. So these shifts in constitutional law and culture fuel an explosion of free exercise challenges to drug bans in the 1960s and 1970s. 1960, an Arizona judge becomes the first to find that a drug law unconstitutionally restricts religious freedom in a largely forgotten case called Attica, because that was never published in a case reporter at the time. The decision also had very little legal analysis in it. For those reasons, the next case in this series out of the California Supreme Court in 1964 became the landmark. That case, which you may have heard of, is People versus Woody. In People versus Woody, you also had members of the Native American Church convicted of peyote possession, like that case out of Montana in the 1920s. But now you have the Shortt versus Werner test and a more favorable framework in which to analyze their claims. And so the California Supreme Court first asked, does this drug ban infringe on this group's religious liberty? Found that a pretty easy question to answer. Said that, of course it does. Their ceremonies revolve around the sacramental use of this plant, and their whole theology is grounded in it. The California Attorney General had actually conceded that point and instead argued that the government nonetheless wins because they have a compelling interest in enforcing the ban against the church on the grounds that, and I'm quoting the California Attorney General, allowing the NAC members to consume peyote obstructs enlightenment, shackles the Indian to primitive conditions, and threatens their health. And the California Supreme Court rejected those arguments. It said that all of them rest on untested assertions and Eurocentric biases rather than credible evidence. And so as applied to these defendants in the Native American Church, the state's peyote ban could not stand. Woody sparked a nationwide reconsideration of bans on ceremonial peyote use. On the same day that it handed down Woody, the California Supreme Court granted a writ of habeas corpus to a self-styled peyote preacher who operated outside the domain of a recognized church and remanded his case to the lower court to ascertain whether he had consumed peyote in connection with a bona fide religious practice. Flash forward to the 1970s, you have the Arizona Court of Appeals, the Oklahoma Court of Criminal Appeals, among others, adopting Woody. Broader change came at the legislative level. Inspired in part by Woody, approximately 24 states created peyote exemptions for religious use of peyote in their drug laws throughout the late 1960s and 1970s, and the federal government does the same. When it first bans peyote in the Drug Abuse Control Amendments of 1965, and then again in the Controlled Substance Act of 1970, it carves out a religious exception for the Native American Church and in its use of peyote. And so you get this clear trend in this window in the 60s and 70s of enacting general bans on this drug while recognizing religious exemption for the Native American Church. Other lawyers and civil libertarians and drug churches and groups immediately see the potential of Woody, and everyone starts to raise a Woody defense to their drug charges. They asserted free exercise rights to use LSD, marijuana, magic mushrooms, and more in cases involving organized religious groups whose dogma prescribed use of those drugs, and in other cases where you just had an individual defendant saying that their personal spiritual beliefs counseled use of the drug. Judges responded to these arguments with a wide range of rationales. The one constant was the government always won. They were unwilling to extend Woody further. Some courts resurrected the old act belief distinction and just refused to consider the free exercise claim in any depth because it involved conduct, not just beliefs, even though the Supreme Court had supposedly foreclosed that move. More courts found that the defendant had not actually used the drug pursuant to a sincere religious belief, either because their church was a sham or because the drug use, I'll quote one appellate court, reflected a personal philosophy and way of life rather than a collective creed. Other courts reasoned that the defendant's drug taking wasn't intrinsic or indispensable to their religion, even if their religion was legitimate, even though elsewhere in free exercise law it was becoming accepted that you weren't supposed to inquire into the importance of a practice to someone's religion. And many courts, including most federal appellate courts, ruled that however large the burden might be on the defendant's exercise of religion, the government's interest in drug control has to trump. And so the compelling interest was there. And in so doing, it emerged that it was easy to distinguish Woody from all of these other cases. Judges who were looking to limit Woody would point to things like the defining role of peyote in the NAC's theology, the highly circumscribed ceremonial manner in which that church used the drug. The church's relatively long institutional history, this came up in the prior panel, the longevity of a church, it dates back to the 1910s as a sign that this wasn't just an effort to game the religious exemptions today. Other judges would invoke the special status of Native peoples in American law. And finally, judges would refer to the low risk of diversion of peyote into the general population, given both the geographic isolation of certain tribes and the relatively minuscule commercial demand for peyote as compared to a drug like marijuana. In every case after 1987 where someone tried to raise a religious liberty claim for marijuana, the federal government would cite the fact that between 1980 and 1987, it had seized less than 20 pounds of peyote nationwide, meaning that the religious exemption granted to the NAC hadn't blown open a market for peyote, whereas it had seized more than 15 million pounds of pot. And so the diversion risk of pot was greater. In light of the fact that the case law after Woody ended up basically confining it to the Native American church and that one drug, it actually was not of great significance for the war on drugs or for religious liberty drug claims when the Supreme Court shocked the legal community in 1990 with this Smith decision that was referred to in the prior panel. In that decision, the Supreme Court got rid of the Shortt versus Werner strict scrutiny framework for evaluating religious liberty claims and said that basically neutral laws of general applicability would not have to undergo that analysis. And so the real significance of Smith wasn't so much that now drug defendants were losing, whereas they previously were winning. They were losing before that too. But it awakened a broad coalition of civil libertarian and religious groups who were outraged by this new doctrine that was going to make it harder to bring religious liberty claims across the board, and leads to the enactment of this landmark federal statute, the Religious Freedom Restoration Act of 1993, which brought back Shortt versus Werner. It reinstated the old, more demanding test for the government to satisfy when it infringes on someone's religious liberty. So now, the legal history gets quite complicated, but in another case in 1997, the US Supreme Court limits the application of RFRA to state and local governments, but it still applies to the federal government. As was also mentioned on the prior panel, a number of states enact little or mini RFRAs of their own. By the time you get to the turn of the millennium, something approximating the pre-Smith, pre-1990 jurisprudence is cobbled together under state statutes, RFRA, and state constitutional religious liberty protections. So now, in other words, we've moved to a more statutory scheme, but defendants are still losing. They're still losing. And courts, kind of following the template that was developed in the 1960s and 1970s when evaluating RFRA claims for drug exemptions, will sometimes hold that the laws in question do not substantially burden the person's religion. Other times, they will just say that the beliefs are not sincerely religious in nature, and most often they'll say that the government's compelling interest in drug enforcement has to trump. Every religious liberty claim involving marijuana has failed under RFRA as under the First Amendment's Free Exercise Clause and its state constitutional counterparts. More generally, there's a lot of empirical literature on how minority religions have fared poorly under RFRA. That all made it quite surprising to many when the US Supreme Court stepped back into the picture in 2006 in this Gonzalez versus Ocentro case and found for the religious group on their RFRA claim. Briefly, this group involved, this came up in the last panel too, a Christian Spiritist sect based in Brazil with a small stateside following. And they wanted to use ayahuasca as part of their religious practices. And the government conceded that the ban on ayahuasca substantially burdens their religious freedom, but made the standard set of arguments about, nonetheless, we have a compelling interest in drug enforcement. We also have international treaties the government invoked requiring us to ban ayahuasca. And these were very familiar moves in RFRA litigation. The new move was from the Supreme Court, which unanimously rejected that argument and in almost disdainful tones invoked what the Supreme Court, John Roberts, called the well-established peyote exception as evidence that these are administrable, workable exceptions for religious groups, and said that the argument that this exception can't be applied to the UDV echoes the classic rejoinder of bureaucrats throughout history. If I make an exception for you, I'll have to make one for everybody, so no exceptions. But the whole point of RFRA is to make exceptions for religious groups, and the international law claims the court wasn't bothered by it all. Many people thought that, or hoped that O Centro would reinvigorate religious liberty law around psychedelics, if not more generally. And then there was a 2009 case out of a district court in Oregon, which applied the same logic to allow the Church of Santo Daime to access ayahuasca. But basically, once again, we have the same pattern of a flowering of, or opening in the religious liberty jurisprudence getting shut down shortly thereafter, at least on my reading, because very few litigants profit from O Centro after 2009. The DEA creates a new petition for religious exemptions from the Controlled Substances Act after those 2006 and 2009 cases, only to deny every single petition that came in afterwards. And so O Centro quickly becomes an outlier rather than a stimulant to a new and tougher reading of RFRA. And just as Woody had done a generation before, O Centro therefore both catalyzes and constrains religious liberty claims for access to illicit drugs. It recognizes the potential sincerity and safety of such drug use, but only when the drug in question grows in the wild, lacks any significant commercial market, and plays a sacramental role in the practices of a church that mixes Christian and indigenous elements. For whatever reason, that has, and we can theorize this, that has been the sweet spot for religious liberty claims in US jurisprudence. Indigenous churches that also happen to be Christian seem to be the only ones who win. And that's where the law still stands on the religious liberty side. I therefore see Woody and O Centro as having a quite ambiguous legacy. On the one hand, in unusually frank terms, they confirm that drug prohibitions can do unjustified violence to respect-worthy communities. Yet rather than spark a broader reckoning with the harms of drug prohibition or legacies of anti-native racism, they ultimately lead to licit, legal psychedelic drug use being identified with and confined to what one scholar calls the Christianized corner of the indigenous realm. In the process, Woody gets converted from the bane of drug warriors, the decision they most hated and feared in the 60s, to a boon, because it allows them to show their reasonableness and restraint while expanding access only to a very small set of substances for a very small set of users. A specific sort of religious liberty claim is vindicated, and a larger structure of illiberalism is legitimated. Let me just briefly, that was my main thrust here, was just to describe that history of religious liberty cases. Less well known, and I'll be quicker here, people also raised free speech arguments against psychedelic drug bans in the 1960s and 70s that did not make as much headway in the courts, but actually partly for that reason, I think are more viable today, because there wasn't a lot of negative precedent laid down because the cases, many fewer of them were brought or reached an appellate court. The free speech arguments came in two main varieties. Some people argued that illicit drug use can amount to a form of symbolic speech, which the Supreme Court had recently recognized could count as free speech under the First Amendment. Others argued, and I think this is the stronger argument, that illicit drug use under some circumstances can be protected by the freedom of thought, which is encompassed by the freedom of speech, as the Supreme Court has said time and again. The first argument, the symbolic speech argument, emphasized the political connotations of illicit drug use. Pot smoking in particular, I'll quote the segregationist Senator James Eastland in a 1974 congressional hearing, pot smoking has been embraced throughout the country as a symbolic rejection of the establishment. And that being a well-known social fact, some academics and litigants argued that, I'll quote one of these cases, my marijuana use constitutes symbolic speech because it implicitly expresses a rejection of majoritarian values. That argument didn't really have legs because judges and other scholars tended to retort, maybe there is some political or symbolic connotation to your drug use, but that's not the main reason why people use drugs. That may be a byproduct. And in some sense, everything we do has some potential symbolic or political connotation. That can't get you a First Amendment exemption. The other argument, however, is harder to dismiss. And this was the idea that drug control can amount to thought control because of not the political implications, but the perceptual implications of using psychedelics and other drugs. You get law journal articles in the late 1960s for the first time riffing off the Beatles, talking about how drugs free your mind, or Aldous Huxley, how they open the doors of perception, making arguments about how drug prohibition, I'll quote one of the best-known articles from the period, might offend the free speech clause insofar as they limit potentially vast sources of information that may be revealed or elicited through drug use, blocking what this scholar called chemically assisted free inquiry. In case you think these were fringe arguments, Harvard Law School's own Larry Tribe, the preeminent constitutional scholar of the day, in his renowned con law treatise from 1978, has a fascinating two-page riff on this question in which he puzzles over how psychoactive drugs could be banned when obscene materials had already been recognized by the Supreme Court in this 1969 case called Stanley versus Georgia to be covered by the First Amendment. And he likens psychoactive drug bans to bans on private fantasies or literary materials. He said all of these could be seen as a governmental invasion and usurpation of the choices that together constitute an individual's psyche. Tribe himself makes a pretty compelling argument for why this is something the court should take seriously. The courts largely did not. The Hawaii Supreme Court expressed some interest in this claim in 1975, but largely it doesn't get litigated and remains an academic argument. Here, I'll just note and close on this, that whereas the argument that illicit drug use can constitute symbolic speech protected by the First Amendment has no adherence that I know of in the current legal world, the freedom of thought argument for a First Amendment-based right to access psychedelics or other drugs actually has acquired a newfound prominence in recent years. For example, in the academic literature, Shauna Schifrin, a renowned legal philosopher, has put forward a very influential thinker-based theory of the First Amendment that, I'll quote her, takes to be central the individual agent's interest in the protection of the free development and operation of her mind. That, Schifrin says, is the core of the free speech guarantee, the right to control your thought and your mind. She doesn't draw a connection explicitly to drug policy, but it's easy, I think, to leverage her arguments to challenge drug bans, and some other scholars have. I won't summarize all their arguments, but you probably can get the gist. Since the 1960s, U.S. constitutional doctrine has also become somewhat more favorable, arguably, to these claims, because there are a number of cases that now recognize a person's right to refuse antipsychotic medications, sometimes not just on the basis of bodily autonomy covered by the Due Process Clause, but also on the basis of intellectual autonomy, the right to control your mind, covered by the free speech guarantee. And then abroad, mainly outside of the US, there's a large literature on what some scholars call the cognitive liberty case for access to psychedelics. This is just the freedom of thought argument from the US in the 60s and 70s, what Tribe was talking about, repackaged in slightly new terms and developed further as a theory. So maybe I'll close with this and say, I think the cognitive liberty argument for challenging at least certain bans on drugs that are relatively safe and predictable in their effects and have the potential to stimulate cognition, sensation, perception, remains kind of uncharted territory for First Amendment lawyers and an argument that awaits further development in the courts. Probably more likely to get traction in the state courts than the federal courts at this time. And lastly, I'll just note that I think there's a complementary move that could be made under the Free Speech Clause. The cognitive liberty argument focuses on the right to, it focuses on the self and the right to control the inputs and processes that underline any given person's cognition. You get to control your mind. There's what we might call an epistemic discovery argument that I think could also be raised, which is more about the effects on the search for truth and society of allowing people to use certain drugs. So if it's the case that, as the previous panel suggested, any percent of the population thinks that a certain technology, let's use a neutral term, makes it 5% more likely that they will perceive a truth or access knowledge they could not otherwise have accessed. I think that should bear on the First Amendment analysis. One classic justification for free speech under our constitutional tradition is that it conduces to the search for truth collectively over time. If we allow people to say what they want in a relatively open fashion, eventually the good ideas will bubble up and will be more likely to achieve truth collectively. If it's right, as people increasingly seem to be arguing, that psychedelics, at least for some people, conduce to their pursuit of truth, that slots in pretty nicely to that marketplace of ideas lineage of thinking about the purpose of the free speech clause, and I think complements the cognitive liberty argument from a social perspective, not just the individualistic perspective. I'll end there and just say, although the free exercise clause and RFRA tend to get most of the attention when we're talking about constitutional challenges for religious groups and drug bans, the free speech clause may actually have more life right now for the reasons just mentioned. Thanks.
I like the term chemical-assisted inquiry. I was thinking if you were, depending on whether you're a materialist or a dualist, it's either all chemical-assisted inquiry or none.
Right.
All right, well, we'll move on to our second panelist. Caroline, welcome.
I have slides. At least I hope I have slides. There it is.
Maybe I should.
Oh.
Maybe I'll go inside.
Oh, I see. Have them appear slowly. Okay. So let me lower this. There we go. All right. So I'm delighted to be here. Thank you for including me. I'm here in my capacity as a law and religion scholar. So I'm going to sort of take a deeper dive into the question of whether there are exemptions available from drug bans. And I'm going to be focusing particularly on exemptions under the First Amendment of the Free Exercise Clause of the First Amendment, which is a constitutional exemption as opposed to a statutory exemption. Because if you qualify for the constitutional one, you will also qualify for the statutory one. So just keep in mind that the constitutional one, you'll see, has 3 requirements. The statutory one has 2 of those 3 requirements. So again, if you satisfy one, you satisfy the other. So again, the question is, may a person be excused from obeying a drug ban in order to practice their religion? And the good news is that recent Supreme Court cases have made religious exemptions more available than ever. It is easier to qualify for one now than even 5 years ago. The bad news is that the plaintiffs who have gotten these exemptions, the ones who have been before the Supreme Court, were conservative Christians. And it's not altogether clear whether this generous exemption scheme the Supreme Court has created will be made available to those whose religious beliefs conflict with, rather than align with, conservative Christianity. All right, so, let's see. There we go. Okay. So under existing constitutional law, religious observers are entitled under the Constitution to an exemption if 3 things are true. I'm giving you a class. I hope that's okay. So first, the law has to target religion for disfavor. Second, as you've heard many people say, the law has to impose a substantial burden on someone's ability to practice their religion. And then the third, the law cannot pass strict scrutiny. In other words, the government can't come back and say, I know this imposes on your religious beliefs, but we have a really compelling reason why this law must be enforced, and there's really no other way we can do it without intruding on your religious belief. That cannot be true. So if all those things are true, then someone is entitled to a religious exemption. And as I said, it's become so much easier. Or at least when conservative Christians sue, the Supreme Court has really lowered the threshold to satisfy each of these three requirements. Okay. So you might think the first one, that the law has to be targeting a religious belief. You might think that a law banning drugs isn't targeting religion. However, according to a Supreme Court very keen to find slights to religion, if a law treats a comparable secular activity better than the religious practice, then the court concludes it is discriminating against religion, it is targeting religion. So here's an example. During a bad COVID outbreak, California banned all gatherings of more than 3 families in private homes, whether religious or secular, right? So the law does not appear to be targeting religion. On the contrary, it's treating religious gatherings in private homes exactly the same way as secular gatherings in private homes. But the Supreme Court argued that barring religious gatherings of more than 3 families in private homes, but not secular gatherings of more than 3 families in a supermarket, was a comparable activity, and therefore it targeted religion. So in other words, this requirement of a law being neutral and generally applicable, the law can't target religion, it's very easy to find that a law is targeting religion. So if a drug ban contains any secular exemptions, and there are certainly medical exemptions in the Controlled Substances Act, then a religious objector can argue that the law is targeting and discriminating against religion because it's favoring a secular use, the medical exception, over a religious use, the sacramental use, right? It is allowing ingestion for secular reasons, but not religious reasons. So again, under the current understanding of what it means for a law to target religion, if there is a secular exemption, then the almost inevitable conclusion under the existing doctrine is that the law is targeting religion. All right, well, what about a substantial burden on religious exercise? Well, here the Supreme Court has become so deferential to religious claimants, or again, at least to the conservative white Christians who have come before it, that this test has almost been reduced to a rubber stamp in the cases it's been deciding. So, for example, making a cake for a same-sex couple who does not live according to your religious beliefs, even if that does not change your own life one iota, the Supreme Court has held, yes, baking that cake is a substantial burden on your religious practice. Or more recently, a public school football coach claimed it was a substantial burden on his religion to pray on the sidelines of the public school football field immediately after games, rather than in the middle of the football field immediately after football games. And the Supreme Court did not even blink. It said, absolutely, your inability to pray in the middle of the football field after games instead of on the side, substantial burden on your religious practice. And quite honestly, it's not altogether clear if there is a distinct requirement of a substantial burden if you can argue that there has been some discrimination against the religion. There's certain cases, the court almost seems to assume that if you have been discriminated against, if a religion has been discriminated against, which it has if there's a secular exemption and not a religious exemption, then you've satisfied the substantial burden requirement. So again, under existing doctrine, this is a really easy threshold to meet, or at least it has been a really easy threshold for the conservative white Christians who have come before the court. But even if it's more is required, someone whose religion, someone who uses drugs for sacramental use should not have trouble satisfying this, right? And in fact, the classic understanding of what a substantial burden on a religious practice is when the government makes it illegal for you to observe a sacrament. So this is a classic substantial burden. It really should not be a problem. And then the final requirement is that the law should fail strict scrutiny. It can't pass strict scrutiny. So again, strict scrutiny is this idea that if the government has a really compelling reason for its law and it's able to show that it can accomplish this interest without infringing on your rights, then the law still stands and you're not entitled to an exemption. And the court here has changed this test as well, really recently. This is all within the last 5 years. Well, some of it is more marked than others. But here, the question is not whether the law advances a compelling government interest, like health or safety. Rather, according to the Supreme Court, the proper inquiry is whether the state has a compelling reason to deny the exemption. And the answer is no, if there's a comparable secular exemption, right? Because what reason could there be to allow the secular exemption and not the religious one? And that's not even getting to the narrowly tailored. So the bottom line is, it should be really easy to win these claims, in theory, under the Supreme Court's doctrine. The law is not neutral and generally applicable. This was a new standard created by Smith, but it's basically faded away, as David explained, in part because of the way they've interpreted it, which is, if there's a secular exemption and not a religious one, then you're discriminating against religion. Clearly, not allowing people to observe a sacrament of their faith is a substantial burden on their religion. And especially if there's any kind of exemption, it's going to be hard to argue that there's a compelling reason to deny religious use when you are allowing secular use, because both of them undermine the government's goals in the same way. So again, in theory, it's a really strong case. And by the way, if we're talking about, I'm talking about a constitutional free exercise exemption. You've heard a lot of talk about the Religious Freedom Restoration Act, which applies to federal laws, or state religious freedom restriction acts, which apply to state laws. Those are the latter two. You only have to show the latter two. You don't have to worry about the first thing. So again, it should be a really strong case. But as you've heard, it's not a slam dunk, as it should be given the existing doctrine, because you have a very outcome-driven Supreme Court, or really any court. There's just no guarantee they're going to be as solicitous of religious objectors whose views clash with sort of accepted conservative goals, rather than align with it. So there's all kinds of ways. In constitutional law, there's always a way to wiggle out of something. A court may say, even if there's a secular exemption, it's not singling religion out for disfavor because the secular exemption is not comparable to the religious one. And therefore, the law is not teaching a secular activity more favorably than a comparable religious one. So they could argue, well, the secular exemption for medicine promotes health in a way that the religious one does not, and so you can't say that they're alike. Or, as you've heard with substantial burden, they have often become a lot less deferential and sort of ask questions that they don't usually ask. And so you've heard of two areas where they might push back against a claim for sacramental use of hallucinogenics in a way they don't with more familiar claims. And one way they may push back is to say this is not religious, because after all, these protections are for religion, not for secular practices. something they would never do with anything a Christian would say, because they're like, Christian, of course, religion, done. Which is partly why the claim with the horoscope probably succeeded, because there was that link to Christian, and so they could not question whether it was religious or not. And then the other place where they're often pushed back, which you almost never see in any other kind of religious liberty claims, is the sincerity question. And usually courts treat it like a hot potato. They do not want to be evaluating the sincerity of a religious belief. And you may think, well, why not? They do all the time. And some people argue, yeah, you should do it. Think about Hobby Lobby, the people who made the argument about providing contraception was a terrible burden on their religion, even though they had been doing it for years, right? There might be an argument for reinvigorating the sincerity inquiry, but it hasn't happened except in this one area. And the reason why courts hate to do it is because evaluating the sincerity of a belief too often blurs or shades into evaluating the truth of a religious belief. And under the Establishment Clause, one thing that secular courts should not be doing is passing judgment on the truth of a particular religion or not. So generally speaking, you do not see courts challenging whether something is sincere or not, although, as you've heard, that's not the case in the kinds of challenges that we're talking about today. And then, of course, for strict scrutiny, they could always just ignore the Supreme Court's recent modification of the inquiry, and instead of asking, is there a compelling interest to deny this exemption, they might go back to the sort of older, is there a compelling interest in this law? And if you say health and safety, that's always going to be a yes. And so I guess the bottom line is, while religious liberty exemptions really have become more available than ever, there is no guarantee, especially with the Supreme Court. Okay, that's kind of a downer ending. So let me try for a better ending. At the same time, most cases don't reach the Supreme Court. And some lower courts, at least, will feel bound to follow precedent and might also believe that religious liberty exemptions should not be for conservative Christians alone. Thank you.
Hello, everybody. So, greetings and good afternoon, friends, colleagues, and fellow psychonauts. It's a tremendous pleasure to be here today and to be part of this conversation. I am somewhat overwhelmed that the experiments, both virtual and actual, that propelled me towards religious studies in the late 80s, some 40 years ago, has reaped the surprising reward of speaking here at Harvard University. By way of coming out, I have done a lot of psychedelics, and I'm saying this on camera at Harvard Law School. I mean, something is different now. And for that, I'm grateful. What a long, strange trip it has indeed been. So along these lines, by way of coming out, and just to add to some of the introduction that Mason made, so I teach at Case Western Reserve University, and as he mentioned, much of my background has been in Indian philosophy and Hinduism. Since then, I have branched out tremendously and have come out in so many different ways and started publishing on the Grateful Dead, and I'm currently president of the Grateful Dead Studies Association, so you can see that it's really part of my life now. And I teach classes with some frequency on drugs and religion at Case, and in bioethics and in the medical school, and of course for the College of Arts and Sciences. So by way of psychedelics, it's something kind of ironic almost, that when one does psychedelics, there's a tremendous amount of neuroplasticity, where one's very categories get challenged, shall we say. and often destroyed. And it's in this kind of spirit, shall we say, that I share with you my thoughts today. And the title of the talk is Relinquishing Religion and Deferring to Darshanas, Letting Loose the Leagues of Spiritual Discoverers. So in this brief reflection, I want to problematize the very category of religion, especially as it pertains to the one developed and deployed in the American judicial system. I contend that the category is no longer useful and that it ought to be jettisoned, as should the dichotomy between secular and religious. And other previous speakers have already mentioned this about the dichotomy between medical and spiritual and so on. The expansion of psychedelics in both allopathic and non-allopathic settings, the growth of so-called new religious movements, and the explosion in the numbers of people identifying as spiritual and not religious are powerful reasons why the category is obsolete and best be discarded. Something funny about this, I'm in the Department of Religious Studies too, so this is very funny. Anyway, but just put that aside. As J.Z. Smith and others have argued, the category religion is a byproduct of European Christocentric and colonial expansion that began during the Enlightenment. And I've heard that constantly repeated here today. It is indisputable that the definitions that have been generated are based on and enforce a Christian template a Christian template and have become paradigmatic in that way. We've heard that in every single talk today. In the American judicial context, the definition of religion, moreover, seems to have a Catholic hue which presumes theism, the need for a priest mediator, and hierarchy, and an importance placed on doctrines and rituals. And it is against this humanly constructed paradigm that new religious movements, and in the current movement, religions that utilize psychedelics or other Schedule I controlled substances in their practices are compared, evaluated, and usually dismissed. The judiciary asks, as we've heard all throughout the speakers today, the judiciary asks, does the tradition in question have a set of doctrines, something like the Bible, someone who has authority over the content, like a priest, or rituals like weekly or even daily mass? And is a Schedule I induced experience a religious one, much less a mystical one? The category as it is deployed in the American judicial context is not a neutral one, as we have heard again and again today. It is no longer useful other than to covertly establish Christianity as an exemplar and to perpetuate, in Mason Mark's terms, cognitive content moderation that fits into a Christian paradigm. It is not without irony that the Establishment Clause violates itself. And as the Pew Research has shown, it is not that useful even for the average American, the majority of whom are identifying as spiritual. While it is indeed noble and perhaps unavoidable for lawyers to try and work within the system and expand the category of religion, as was mentioned earlier today, I think that doing so is futile. I'm so sorry. I'm sorry. And inadvertently reifies and buttresses an obsolete category. My perhaps idealistic and ivory tower suggestion, and to say this here at Harvard is really funny, an ivory tower suggestion is to abandon the term religion altogether. So you may wonder, what should be put in place? Spiritual or something entirely different? Viewpoints, darshan. When I teach Indian philosophy, usually under the auspices of a religion department and sometimes cross-listed with the philosophy department, I ask students at the end of the semester if what we studied is a religion or philosophy or something entirely different. The Indian thinkers utilize the Sanskrit term darshan, often translated as viewpoint. Most students agree that neither religion nor philosophy, not even school, does justice or captures their essence, and not surprisingly, that the term darshan does. Each darshan offers an ontology, theories about what exists, and epistemology, theories about the grounds of knowledge, that were joined intimately and inextricably with the correlate soteriology, theories about salvation. Each darshan thus has presuppositions that are transparent and are the fundamental structures of their, to use Wittgensteinian terms, language game. This includes logic and what constitutes a flaw in logic as well. Surely you would agree that everyone has a darshan, or call it, if you prefer, a set of foundational metaphysical presuppositions whether they admit it, recognize it, or acknowledge it. To this end, it is possible to distill someone's ontology, epistemology, axiology, and so on from a text, from observation, and from conversation. Almost all claims, religious, economic, political, secular, and so on, are based on an explicit or implicit darshan or metaphysics. You may object, and since we're at the law school, people, I guess, object a lot here, right? You may object that there seems to be an overlap with philosophy. I would agree that there is an overlap, but that the term philosophy, like its counterpart religion, is fraught with bias and historical baggage. It may have included practice in the distant past, as Pierre Hadot has argued in his Philosophy as a Way of Life. It no longer does, though. And I think metaphysics has taken on a life of its own, and one would be hard-pressed to wrestle it from the grasp of those who identify with it. Anyway, for this enterprise, let's set aside metaphysics and philosophy. What would the American judicial system look like if, quote, Congress shall make no law respecting an establishment of a viewpoint darshan or prohibiting the free exercise thereof? And if having a viewpoint was having an ontology, epistemology, and axiology, then what way of thinking and acting wouldn't fit into this category? Practices, beliefs, and communities that were formerly characterized as religions would lose their status as exceptional and as exceptions to the rule. Scientific claims would be on par with formerly religious ones. More broadly, I think that that evening of the playing field could give all participants some epistemic humility. Claims made in one language game could not be fruitfully evaluated by the rules of another. Or, as Wittgenstein put it in his lectures and conversations on religious belief, when referring to claims made by religious people, that they have a different theory about what constitutes evidence than those who appeal to science. The distinction between secular and religious would cease to exist. Religious claims, practitioners, and institutions would be no different from those now considered secular. The current definition of religion suffers from under-inclusiveness, as is evidenced in the exclusion of many new religious movements, psychedelic orientations, and so on. In contrast, darshan, and perhaps metaphysics, if you really need to go with that, is superior because it is indeed and happily over-inclusive. I see no problem with this whatsoever. Surely this increases rather than decreases the number of conversation partners and the number of applicable or practices that are permissible, shall we say. As for adjudicating between the darshans, again, it makes no sense to evaluate the claims from one language game using the logic and presuppositions of another, and this is the unusual and customary in most judicial systems. Debate in Indian philosophy thus concerns possible internal inconsistencies in the relations between a school's ontology and its epistemology, and so on. The drive was always to uncover flaws in what appeared to be an otherwise healthy and coherent philosophical system. Competition between the schools of Indian philosophy involved showing that one's own system was more coherent, more convincing, and easier to follow than others. Conversations are thus approached with a modicum of epistemic humility. And foundational, of course, here in America, I suppose, should be some version of Locke's letter concerning toleration that permits debate and dialogue to occur at all. Darshans are permissible if they do not threaten debate itself and do not violate a sort of non-aggression principle, and participants can pursue lines of questioning with audacious irreverence. These rules, of course, are themselves debatable. Lest there be an anavasta, in Sanskrit that would be an infinite regress of sorts, that is to say, how do we argue about how we argue, they ought to be upheld stipulatively. So you may wonder, what does this have to do with the current controversies concerning psychedelics, New Age religions, and spiritualities? Leagues of spiritual discoverers. With this new viewpoint and orientation, members of psychedelic churches will not be prevented from exercising their rights to have and follow, or even a multiplicity of viewpoints. Similarly, New Age and solo spiritualists will also be free to practice as they wish, so long as they do not violate a non-aggression principle. I take it from earlier conversations, I'm not trained as a lawyer, that this would be strict individualism. Is that how it's phrased? Something like that? No, not quite? Okay, then I retract that. Okay, sounds good, Deepak. What about these Schedule I substances, so-called drugs, you may wonder? It is here that I think that one should consider Mason Mark's insightful article, Cognitive Content Moderation, Freedom of Thought, and the First Amendment Right to Receive Subconscious Information. And when one reflects on the history of the term religion and its Catholic connections, then one ought to recall the Index Librorum Prohibitorum, the Index of Prohibited Books, which was instituted from 1560 until 1966. Add to this the Catholic belief that priests are indispensable mediators between lay people, which has been mentioned earlier today, and the divine, and it is no surprise that cognitive content that is obtained by means of substances would not be approved, as was mentioned earlier as well. Drug-induced experiences, according to these paradigms, are not mystical ones. It seems arbitrary, if the category religion is no longer accepted, to decide which cognitive states are acceptable, which are not, and in which context. So do away with religion, so to speak. The issue is made even more confusing when one considers the use of psychedelics in allopathic settings, which certainly have their own presuppositions, I am sure you will agree, and could then be constituted as darshans. Connecting psychedelics to wellness adds to things, since wellness seems to include and integrate the allopathic with the spiritual and so on. If these are permissible, then this seems to warrant letting loose the League of Spiritual Discoverers. The need for a mediator is made irrelevant once the term religion is relinquished. Dispensing with a mediator is akin to no longer moderating cognitive content. Individuals can explore the content on their own, or if they wish to seek mediation or help or interpretation from others. I think this trajectory is not a new one. Rather, it is consistent with American spiritualism, which had an important node, as I'm sure you all know, here in Massachusetts and at Harvard via Thoreau and Emerson, both of whom several courts have ruled were not religious, but they were darshans, trust me. In this brief reflection, I problematize religion and argue that the category ought to be abandoned. I argue that it ought to be replaced by darshan, or one like it, that acknowledges the centrality of ontological and epistemological presuppositions that undergird all beliefs, belief system, orientations, and so on. In so doing, religion loses its status. Communities that use Schedule I substances will just be one among many, 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 and Americans, I think, will be more free. And I realize that all of the conversation this today has presupposed religion, and people have worked within those confines. It is my job to destroy this category. And if I have if I planted the seed of doubt in your head, then I have done my job. And if you've been open to this planting, then you have done your job too, because it shows that you have epistemic humility. Thank you very much.
I have so many questions. And I suspect that you do as well. I want to give the panelists an opportunity to react to each of their presentations. Any of you.
Okay, I'll be quick. Those are great, stimulating talks. I'll just offer maybe a thought on each one. Caroline, I guess I'll just reiterate your skepticism that the current federal courts would recognize free exercise claims to drug use, but notwithstanding their general trend of making it easier to bring these free exercise claims. I think they would stop at step one. So you only get to strict scrutiny, the tough analysis, if you can convince the court that the law is discriminating against religion. As laid out in this 1990 Smith case, if the law is a neutral law of general applicability, then you've lost already at the threshold. And Smith itself was a drug case, and for many federal judges then and now, drug bans are almost the paradigmatic neutral law of general applicability. They're not out to harm religion or hurt religion, crush religion. They have a public health, public safety rationale, even if they may happen incidentally to burden some people's religion. So I think for most federal courts, notwithstanding the plausibility of the arguments you heard and the way in which you could work within the liberalizing doctrine, it will be a reach. And Deepak, that was more profound than I think I could offer. Any legal take would not be adequate. But I'll just note that you used sometimes the word viewpoint to describe the better categorization than. That is also a First Amendment term of art, yeah, because the bedrock principle of free speech jurisprudence over the last 50 years or so, the court has said again and again, is that the government can't engage in viewpoint discrimination. So to that extent, the courts would be with you, but there they would say that a drug ban doesn't discriminate on the basis of viewpoint, rather it only prohibits certain types of conduct. So they would distinguish views or speech from acts or conduct. And so you couldn't, for example, prohibit pro-drug advocacy. That would be viewpoint discrimination, picking sides in that debate, but you could prohibit drug making and taking. I hear you to say, however, that the distinction between drug making, taking, and one's views about drugs in relationship to the good life that's an unstable distinction. We should explode that distinction. So whereas we might respect the distinction where someone, you can advocate stealing, but you can still proscribe the act of stealing, maybe drugs are more deeply integrated into certain belief systems or viewpoints, so that we should be more skeptical of distinction. That I think is a really intriguing argument.
So just a quick response. Smith, in a way, is no longer good law, in that tandem has replaced the neutral and generally applicable approach with the religion as the most favored nation. This is getting too technical. Yeah. But the idea is, again, you have to treat religion at least as well as any way you treat something secular. And so it's a very different understanding of what it means to target religion. Smith had the more traditional understanding of targeting religion, which is that you intentionally want to do some kind of harm to religion, or you're singling something out really because it is religious. But that understanding no longer obtains in the jurisprudence, although I think you're still ultimately right, because they'll fall back on it when it suits them. But at least with the kind of claims we're seeing today, at least with the claims, I'm sorry I keep repeating this, but conservative white Christians get what they want. And this whole jurisprudence has been built to make sure that they can get what they want regardless of the consequences to everybody else. And with Christian nationalism in mind, I was thinking about your idea, and I had a little bit of an uh-oh too, because I think what we're really seeing now is a court that's sort of allowing us to regress in terms of equality, in terms of how we treat women, in terms of how we treat the LGBTQ population, in terms of how we treat religious minorities. And the first step is to allow these conservative Christians to treat them unequally on the basis of religion. And so you can have a baker refuse to serve a same-sex couple in the name of religion. And you can have a company refuse to provide women with necessary health care in the name of religion, et cetera, et cetera. And it's a terrible development, but I'm thinking at least it's confined to religion. And so if we eliminate religion as a category, then I worry that in the reality, how would that actually look? I know you're thinking up here, and I'm thinking like, what's it going to do in the bake shop, right? And I worry what it means is it's not just those claiming religious reasons to treat our fellow citizens as less than, as not fully human, as not entitled to dignity and equal access. And it won't just be limited to the religious, it would be available to everybody. And I think this court would be happy to expand it because they hate those developments and they're delighted to make inroads in them with religion. But as I say, at least as a category, it's limited to religion. So that's my sort of pessimistic reaction to your very interesting thought experiment.
So thank you so much for your thoughts. So first, I was thinking about this chemically assisted free thinking, and if one thinks of one expands it in this way, then I think one could get away with what was the conduct then would be applicable. Clearly, I'm not a constitutional lawyer, so I apologize for it. But the point that you made is that it's a good one, right? Is that what happens with what happens with this kind of truths that we ought to follow that are, say, social justice-oriented truths and so on. And here's where things get a little messy. And I've written about this elsewhere, and it's gonna appear in different places. Is that if everything's a construction as I see it, right? And if there's no epistemic certainty as I see it, then you would have to convince me that so for example, one of the outcomes of that is the Yogacara school of Buddhism, where things are all chitta matra, kind of like the Matrix, that things are just mind only, right? So then you'll have to convince me that all of you really exist, and you can't, right? I mean, you can't actually do that. And now I should really make a joke, is that you've spoken of DMT and you'll have that correlated. But anyway, that's a joke. But so then how does social justice fit into something like that kind of perspective, which I call kind of a skeptical nihilism or something like that. And that's, I've already suggested that looking for internal inconsistencies is, if everybody has to buy into this fact that your belief system can be destroyed if there's an internal inconsistency. And I've written, so in the Indian context, this is called Samvad, the debate. I've written about this as well, is that if the playing field is that everybody has presuppositions and that everybody ought to have internal consistency, then if you can show that your opponent is internally inconsistent, then that position is no longer fruitful or no longer can be respected in the same way. So, in the same way that, so learning your opponent's position then. But you're right. There's the danger of all of these of things like social justice, which I have to say is just another constructed position, but a good one, right? And sometimes I answer that with kind of a Buddhist position, which is that it's kind of almost like a Benthamite sort of situation, which is that you have to eventually convince everybody that all these positions are humanly constructed, and then you have to maintain a kind of social order to do that. And that would be, Eightfold Path and so on in the Bodhisattva vow, which is that you temporarily kind of accept that people exist in order to help them see things differently. But it is a danger. I agree. I'm sorry. But I agree. But this is the outcome.
We will take questions from the audience momentarily, so ready your questions. And but I want to first pose a question about treating religions, treating religions at least as well as the secular. And there's a trend we're seeing of state legalization of psychedelics that tend to prioritize the medical secular use. Colorado, home to the Masterpiece Cake Shop, is one of those states. Colorado actually has a state tribal and indigenous task force that recently, just about a week ago or so, voted to recommend that the state not commercialize medical use of many psychedelics, so DMT, mescaline, and ibogaine. And the state's currently making rules to regulate psilocybin for medical use, and this task force asked the state to pause. And I wonder what your thought is on, actually, one of the members asked the Attorney General's office, could a tribe sue the state? And I'm interested to hear your impression of this idea of if a state is to prioritize medical use over, and sort of punish in a way. Do you think that would target, do you think that type of law would target religion potentially, and how might a court view a case like that?
Again, not my view of targeting, but the doctrinal, the law right now, again, is if you have a law and you are treating a secular activity better than you're treating the religious activity, and they're comparable, that's the big if, right? If they're comparable, if they both pose the same risk to the reason why it was banned in the first place, then you are discriminating against religion. Then you are targeting religion. So that's the law as it is today. So again, the big question is, can you characterize the medical use as comparable to the religious route? And when I say comparable, I don't mean the activities themselves are similar. I mean that they pose the same risk to the reason why they were regulated in the first place. So the argument is, if you're allowing the use of a dangerous drug for medical reasons, and it's dangerous because you're using a dangerous drug, why aren't you also going to allow the use of that dangerous drug for religious reasons? Because it poses the same dangers, it's the same drug, right? And so that's an argument that they're comparable. And if that's what's going on, then under existing rules, existing Supreme Court precedent, that would be considering discriminating and targeting religion because you're treating a comparable secular activity more favorably. On the other hand, if you say the medical use does not pose the same risks as the religious use, then you can say you're not treating comparable activities differently. You're not treating a comparable secular activity more favorably than the religious activity that you're trying to get an exemption for. And treating things that are alike differently is a problem. But if they're not alike, you don't have to treat them alike. And that's not considered. So it very much comes down to how you characterize the riskiness of the use, which was what I think we were hearing about earlier. But that's the law. And as I said, often in constitutional law, there's play in like you have the rule, but how the rule applies, there's a lot of play in how it actually parses out. And so that's the question for your particular case, particular question.
Maybe I think that's right, and think that courts would find that medical exemptions don't discriminate on the basis of religion, as you suggested at the end. I'll just say something a little bit on the diagonal, which is I find very unsatisfying the emphasis on medical use as in drug regulation in the U.S. The Controlled Substance Act, for example, the federal framework statute, you probably all know, talks about drugs abuse potential, and that's weighed against their medical utility. That is, I think, unsatisfying on at least two levels. One is that the medical versus, let's say, recreational divide has always been fuzzy, and legal scholars are pointing that out, going well back to the birth of the CSA. I think it's become even fuzzier in an age when mental health is recognized as a health issue. But second, and I think more fundamentally, it's just a bizarrely and I think indefensibly truncated analysis to posit that medical applications are the only benefits worth caring about as against abuse potential. In the rest of American administrative and regulatory law, generally what agencies do when they're figuring out how to regulate something, what should the pollution standard be, or they do a cost-benefit analysis, and they are supposed to aggregate and weigh all benefits implicated by the activity. And that may not always work perfectly, but that's the aspiration. I often say in the drug space, and only the drug space, we do CBA, cost-benefit analysis, without the B. Like if we just exclude and count implicitly weight as zero all of these spiritual, religious benefits that some drug users at least feel they receive, not to mention social ones, or fun, or raving, or intimacy, or what have you. So the drugs have all of these hedonic, pleasure-related benefits. For some users, eudaimonic or meaning-related benefits. They currently get zero weight in the calculation of how to regulate any given drug. So I would just expand the frame beyond religion and think that in all drug scheduling and regulatory decisions, there should be a full accounting of all the benefits as well as the costs.
Absolutely. So if I may just add to that, it's hard not to think of Foucault and biopower and then the correlation of that with the pharmaceutical industry. But, being here at Harvard, it's interesting. If you read Varieties of Religious Experience, that little section on where James experiments is with nitrous oxide, he has all kinds of anecdotes of other people who are experimenting who are all doing kind of like early kind of anesthesia, right? And there are doctors who are doing anesthesia on their own to see if it works, things like ketamine, clearly. And that they, it's interesting that somebody like James thought that these substances that were useful in a medical context also had these other effects. That along these lines, we constantly use the word drug, but entheogen. There are all these other terms but once we use the word drug, it's already been judged, shall we say, right? And then once you put it in the allopathic concept and you say drug, then you say side effect. And so the way you were just describing it, the side effects that include unity, oneness, or whatever are side effects. Just as, my mom had heart surgery a couple of years ago at the Cleveland Clinic, and before they gave her a lecture about what she was going to experience when she had anesthesia, and they're like, these are all side effects. And I was like, no, Mom, these are not side effects. These are like, the good stuff. But like what one person's side effect is another person's good stuff, right? So, or something like this. One man gathers what another man spills, or something to that effect. Anyway.
All right, this is great. We'll take some audience questions now.
Oh.
We'll get our microphone, and if you would like to step up first.
Thank you very much for your insights regarding this topic. My name is Osiris Sinue Gonzalez Romero. I come from Mexico, and currently I am a postdoctoral fellow on psychedelics and spirituality at the Center for the Study of World Religions. I have two questions for the panelists. The first one is for the first speaker regarding cognitive liberty. And the straight question is how to guarantee the right of cognitive liberty for everyone, right? Due to the fact that, for example, the war on drugs and politics of prohibition, the war on drugs is not only a war on pills, powder, plants, and fungi, but also on consciousness, right? And also, for example, the politics of prohibition undermine cognitive liberty, freedom of choice, right? Freedom of religion or religious freedom, self-determination or mental autonomy, and freedom of thought, right? Some scholars, as Charlotte Walsh and Richard Boyle, right, argue that, for example, the politics of prohibition undermine this right of cognitive liberty. So they use the word right. We are in the Harvard Law School. So how it would be possible to guarantee, right, the right of cognitive liberty for everyone, right? This is the first question. The second question for the third speaker is how to move beyond or how to overcome this dichotomy between the religious and the secular, right? Because it seems that we are moving in circle, right? I appreciate that it's very important, for example, to reflect critically on the framework, to develop accurate frameworks, for example, metaphysics, religion, and spirituality. But how to overcome this? Because it's very common to talk about psychedelic science, right? Or religious freedom. But for example, the role of psychedelic humanities is frequently overlooked, right? And for example, the concept of a spirit is also problematic from an indigenous perspective, right? I used to talk indigenous philosophy for 3 years in Mexico. I am a Nahuatl speaker, right? And also, for example, if the concept of religion is problematic, no, using your same, argument, the concept of a spirit or spirituality, for example, it's also problematic because, for example, in which indigenous language, right, it's possible to talk about the spirit, right? So, for example, how it would be possible to overcome, right, this circle or these vicious circles or repetitive circles between the secular and the sacramental use. For example, here at Harvard, for example, now it's running the Harvard Study of Psychedelics in Society and Culture program, right? So it will be important, for example, to recognize different cultural uses of psychedelics. There are at least 7 different cultural uses of psychedelics, but now we're still moving.
These are great questions. I want to make sure we give them time to answer.
Yeah,
I appreciate them.
Yeah.
They're excellent.
Yeah, only one question. We are moving with the United Nations framework. The United Nations World Drug Report in 2023 recognized 3 cultural uses: medical, right, religious or spiritual, and non-medical. But there are at least 7 different cultural uses. How to overcome this circle? Thank you.
Thank you.
I think I should take the first was, I think, directed to me on how to cognitive liberty, how to make it something that everyone can realize, the right to cognitive liberty. So here I'll just say, I think we could imagine a thin and a thick version of a right to cognitive liberty. The thin version is more plausible in US law, but would not guarantee it in practice for everyone. Okay, so what do I mean? The thin version would look like the government cannot prevent and punish you for accessing things that enhance your cognitive liberty or allow you to achieve cognitive liberty, at least without a compelling justification. So it's on you to go and figure out what you need for your cognitive liberty and actually acquire it. The government can't get in your way, again, without a really good reason. And that was the flavor of a lot of what people were arguing in the 60s and 70s. Like, if psilocybin really opens up your mind, then the government shouldn't be able to ban you from it. So in US law, that would be framed as a free speech or free thought guarantee. In many other countries' constitutional systems or in international law, it might be framed as part of the free development of personality, which is recognized around the world. Okay, the problem there is still lots of people, the first panel, there was some discussion of access and affordability, aren't actually realistically gonna be able to acquire things that will enhance their cognitive liberty, whether because of limited resources or not being part of the right communities or what have you. So then the stronger or thicker version would be like a positive right, an entitlement to the things you need to realize your cognitive liberty. The government would have an obligation to make sure you could access those things, not just a prohibition on punishing you if you do. Under US law, however, that argument's probably a non-starter because for many years, people have argued that, if I have a right to free speech, I should have a right to the things that are functionally prerequisite to exercising my speech, most obviously education. And the court has said no. Even you don't actually get any positive entitlements out of the free speech guarantee. You have no right to a high quality or adequate education under the free speech clause. So likewise, you don't have right to enough money to be able to speak effectively or be heard. So there are all kinds of resources, and affordances people might need to realize all of their First Amendment rights effectively. and the court has not been receptive to that. So I think just in terms of U.S. law, probably step one is just for people arguing for cognitive liberty is don't allow the government to punish things that genuinely open up cognition and perception and sensation absent a really good justification.
Hello, thank you for your questions. I have 3 answers I'll give you. The first one is a joke, which is that everybody should do DMT or LSD and they will no longer think that these constructs are reified, right? So I think that the biggest problem is that people think that terms and terminology are set in stone and that they reify them. And my job as a professor in the way I function in the world is to make people question that. Take a look at my Huffington Post piece, What Makes a University Great, Deepak Sarma. Look up my Deepak Sarma and look up APA. And you'll see 2 things that I wrote just about this. So how do I do this? Take my class. All right, that's one thing, which clearly you can't do. But I strive every day to be, get at least some, I'm the distinguished professor in the public humanities is because I go on TV as much as I can to get people to question these basic presuppositions and to question these constructs. And I do that with every class I teach. And I hope that there's some trickle down or something like that, and that they are, like I say to my students, I want to infect them with my confusion, like Socrates did in the Meno. And that if I get to do that and they get to confuse somebody else, then I have done something. And if I've confused one person here today, anybody a little confused? Anybody? Raise your hand if you are. A couple people? Great. You see, that's how I do it. This is how we do it. I hope that answers your question. Yeah. A little bit?
We are a little bit over time. I don't want to keep you from your other Valentine's Day festivities. But I do want to thank you for joining us for the 2025 Pulse Conference. Tomorrow, there is a Psychedelic Intersections Conference at Harvard Divinity School, so hope we'll see you there at the Center for Study of World Religions. Thank you so much to the Mahindra Humanities Center and the Harvard University Study of Psychedelics in Society and Culture program. Sign up for that newsletter so you're up to date on all of our events. Thank you so much and have a great weekend.